Vice President.
Senator Sobers.
Right. So when last we broke before lunch, I was going through this issue that I had with the warrants. And during the luncheon period, I had some discussions, and maybe in terms of what was being put forward was a little bit academic in nature. So let me try to break it down a bit, right? Let me try and break it down a bit. Basically, what I want the public to understand and this House to understand, let's give you an example, a proper scenario. The police, before they approach an officer, a magistrate, or a justice of the peace to procure a warrant, they have to go with information. Information would usually find its way in the form of surveillance or information from a criminal informant who they may have been watching for a particular time frame. Based upon that information finding its way before that particular officer, the magistrate or the justice of the peace would usually grant the warrant. Now, in most instances in this country, police officers would go before a justice of the peace because in most instances, the reality is the police officers are very familiar with the JP, right? And the information, unfortunately, that is put before the JP may not be as comprehensive as we would like it to be. So what this bill would now propose to do is that an officer would go before a master and basically indicate under the particular section that, listen, we have information on John Brown who lives at number 24 Clarence Rambrat Lane, right? And whilst watching him live at number 24 Rambrat Lane, we know that he lives there. We know that he is has control of that particular location because we may have a lease agreement or a deed or whatever in his name. We've conducted surveillance for quite some time, seeing him go into that property. But with respect to the legislation now, we are able to say to the master that in terms of watching John Brown from time to time would visit number 22 Ministers Lane. And from time to time, he may visit number 19 Moses Lane. We cannot say specifically what occupation, what the actual address for 23, or we can't say the address for 19. We can possibly inform the master that in terms of occupation and control, we have no proof of control. We don't have a deed, we don't have a lease or anything tying John Brown to these other two properties. All we have is, in some form, a bit of occupation because we saw him spend a night at number 23, and from time to time he would go at 19. And based upon that, we put that information before the master, and we are to get a warrant now to raid premises and, that are occupied or in control for John Brown. So we would capriciously now go, raid number 24, which we certain belongs to John Brown, and then raid 23 and raid 19, and if we so desire on that particular day, we raid 18, 17, 16, 15, 14, 7, 6, 5, and we go down the road doing those things. Now, I don't suspect or suppose the number of officers who may intentionally operate like that are very few in nature. But there are very young police officers out there without proper guidance may very well unintentionally do something like that. And yes, the law provides in some instances for persons to take action against the state for trespass if the person enters their home illegally and whatever the case is and nothing is found. But now you're going to have them having a defense of this search warrant which indicated that pursuant to certain information they presented, it was sufficient enough for them to get a warrant to say that they could raid John Brown's home, which is 24 Rambrat Lane, and any other premises occupied or in control by John Brown. It is too wide. It is too open. And that definitely mirrors, when you think about it, a World War II scenario, a Gestapo situation. And we cannot have that in this country. Yes, I understand what has been put on the record by the Honorable Attorney General and the government, that this particular part of the legislation was taken from PACE. But I must say, in terms of listening to some of the contributions in the other place, and even in my own understanding, PACE is set up in a particular way to treat with a particular set of police officers in another country that operates totally differently from how we operate here in Trinidad and Tobago. And you simply just can't copy and paste legislation without understanding the socioeconomic instances at play within our own country. It just wouldn't work. It would be simply fitting a square peg in a round hole. That can't operate here. And in terms of going further, when you consider the aspect of multiple searches as well too, I looked at it and I said, but what is the sense? What is the likelihood of an individual who is so steeped in criminality that, one, they're going to have drugs and guns at their home or at their premises that they control or occupy? In most instances, especially if it is the police raid that particular establishment once and they find anything, bet your bottom dollar you will never find anything at that location again. They aren't that silly to have something there on a second occasion. Lightning just simply does not strike twice in such an instance. In most instances, when you deal with criminals or individuals who operate in that realm, they don't hide those things at home. During the break period, it made me think, as I was speaking to a particular officer, I remember in my second day of call, we were doing a matter where an individual's house was raided. And when we visited the police station after they brought him in, he kept saying that they didn't find them drugs and guns there. They didn't find anything home by me. They find that by the neighbor, which is usually what some of them say from time to time. But when we spoke to him and we took proper instructions, what he told us was the police raided the home. They had a dog. They passed the dog through the house. And as they passed the dog through the house and they went into the yard, the dog kept going to the back wall of the property and scratching the back wall of the property. And the way in which the property is located, the back wall now is a wall that is utilized by the neighbor's house as well too. And the neighboring property, the persons who occupied that home were two elderly individuals. One of them, the male, was senile. He couldn't hear, he couldn't speak properly, whatever, and he was bedridden. And his wife, an 87-year-old lady, was equally a bit senile as well too. So the dog is scratching at the wall. The police officers go around and start ringing the doorbell to enter the property. No one comes out. The neighbors now come out and say, well, listen, they indicate the situation with the occupants. The police gain entry. And while they go down to the back wall where the dog was scratching, they told the other officers, let the dog go, and they hoisted the dog over the wall. And as the dog landed in the yard, he scratched and drugs and guns. Now, when we were here a bit earlier on in another debate, if that particular legislation was passed, Aji and Aja was going down the road no bail. Because it was enough drugs and guns, first-time offenders as they would have been caught by that trafficking legislation in the bail amendment bill, and it would have been no bail for them. Right? No, well, for trafficking in drugs and guns, yes, you would be able to get bail for a first-time offender. Well, all right, no, right. So they would have been arrested and taken out with no bail. The police officers enter the property now, find this cache of drugs and guns. And from what we understand, they would have radioed for a senior officer to come on site. The senior officer would have instructed the majority of the police officers to leave the yard. And then it is alleged that he would have given instructions. Well, we know them drugs and guns don't belong to Aja and Aja. Pick it up and throw it over the wall. And they did that, and they charged our client. At the trial, those instances would have come out based upon cross-examination, and he would have been found not guilty. But it goes to the meat of the matter that in most instances, individuals steeped in criminality do not keep those items at home. So to think then that raiding the place a second time, you would find anything there is really and truly wishful thinking. And that is why in terms of this entire section, it must be jettisoned from the bill. It cannot be supported. When I read further on as well too, as it pertains to the showing of the warrant at the execution of the search warrant at 2E, and it indicates that the officer should identify himself to the occupier, and if not in uniform, shall produce to him documentary evidence that he is a constable. when last we were here, we made amendments to that omnibus legislation that dealt with several arms of the security forces. And then we recognized that there was rampant criminality in persons putting on uniforms and imitating police officers and raiding homes and whatnot and whatnot. And because we understand and appreciate that that is what is occurring currently within our society, I'm thinking that at A, now I welcome the fact that we are actually legislating now for what should take place with respect to warrants. I think Senator Hussain, the Honorable Attorney General, Senator Chota as well, too, went through the importance of legislating that because of the different issues that may arise within that may arise within a matter. But what I would want to put for the consideration of the Honorable Attorney General is that with respect to whether or not the officer is in uniform, he should produce an identification card to the person so that they know, or some form of ID so that they would know that this person is in fact a police officer and not some rogue imitating the police and trying to gain entrance to their home. Right? Now, I also saw in the law, which I thought made some sense. I mean, on the last occasion, we spoke about it when we dealt with this particular bill, the fact that items that may have been seized by the police, in some instances, if they don't, they can no longer further assist the police in terms of conducting their investigation or even bringing, subsequent to a charge being laid against an individual, that the item should be photographed and returned to the individual. I would have raised on the last occasion that it opens the state to a plethora of civil actions in the form of detention and conversion being filed against the state. And I'm happy to see that in legislation, because in practice, some officers would take the photographs and then return it to the owner. In some instances, you would have to get an attorney to send off a pre-action protocol letter for detention. I'm glad that it is now in legislation so that you would be able to positively point the officer as to what the law says, and hopefully he complies. And in any event, for whatever reason, when you read further, if the officer does not comply, then an application could be made by both the prosecutor and the owner himself at court to have the item released, which I think is a welcomed approach because it would save the state a considerable amount of time, resources, and money as well, too. I saw as well, too, that the bill has been amended now to allow for a registrar of the court to have concurrent jurisdiction as a master and a magistrate in certain aspects. Now, while I think this is a good approach, the difficulties, and I know that in all instances now, a registrar would be a legally trained individual in terms of his profession as being a lawyer. I just want to ensure that the registrars as well, too, they are very well aware that they are going to be taking on this particular mantle. Because time and time again, we've seen in some instances that persons have been a bit apprehensive about exercising their duties when thrust into that particular position. Grateful, please, Mr. Vice President. So I want to ensure that sufficient training would have taken place and that the registrars appreciate and understand their responsibilities that they are now going to be, that they are now going to have to execute. I also thought it fit that some of the time frames would have been curtailed as well too in this legislation, and in some instances removed. I thought that that was a good approach as well too, as it pertains to understanding that in terms of preliminary inquiries, sanctions operating in a criminal environment may not be the best or most fertile approach to treating with the legislation. With that being said, Mr. Vice President, I do understand the eagerness for our society to rush to have preliminary inquiries abolished. Many persons have suffered under the mantle of being involved in that particular environment for far too long. But we should caution our pace at which we attempt to do it and not rush into actually doing it, because in some instances you would have an unfortunate opportunity or an unfortunate instance where you would include provisions that will serve or do no good to the end users of this particular piece of legislation. I can see no good coming out of including that entire warrant section, apart from either A, persons would intentionally abuse it, or B, those who unintentionally access it will do so without proper training and proper education. There will be a lot of abuse that would be meted out to members of the public who should not be in the crosshairs of such antagonistic behavior. And I think we really need to focus a bit more on ensuring then that we don't only just speak about justice being on time and justice prevailing and indicating to the public that there's this big architecture or plan at work to ensure that the criminal justice system finally takes off, but we actually feel it, because it's the saying that he who knows it feels it, and the only way for us to actually feel it is seeing it operate in practice. We all know the situations at the courts throughout this country, especially in San Fernando, Rio Claro, and Princestown. And I applaud if the case is that we're going to have now 100 courts in Port of Spain for criminal matters to be heard, but the situation in San Fernando still persists. Senator Choate spoke about this recording system and whatnot. I've not heard anything about that system being implemented in San Fernando or Rio Claro. Well, I mean, these are things that we would have to really wait and see and take on board. And we would hope that they actually bear fruit and it extends to all persons throughout the system. I thank you.
Senator Vieira.
Mr. Vice President, today is historic. And today we form part of history. It is fitting that today we are doing away with the Indictable Offences Preliminary Inquiry Act, Chapter 1201, which took effect on the 29th of May, 1917. A process which has become archaic and out of sync with the times. Today also will be the last sitting of the Senate, and probably the last sitting in this place. Today we bid farewell to these salubrious premises which have served us for so well. When next we reconvene, it will be back at our ancestral home. Necessary endings, new beginnings as we look towards 2020. The significance of the moment should not be lost on us. Once in the early 1990s, when I was a prosecutor in the British Virgin Islands, I was tasked with the prosecution of a rapist. The victim was an attractive young American woman who had come to the islands for a sailing holiday. Now, cruising is a very important tourism activity in the BVI. So it was important to show that this sort of illegal activity was heavily frowned upon and that the offender would feel the full weight of the law. The police had their man. He was known to the victim, so identification was not a problem. And on paper, it seemed like a relatively simple and straightforward case. And now in those days, and I don't know what it's like now, but in those days, the criminal courts in the BVI were not congested. Right? Matters moved through the system swiftly. In fact, I had the distinct pleasure of being able to successfully take cases from PI stage to the assizes and appeal, all within a 2-year time frame. A very far cry from what was happening in Trinidad at the same time. But I digress. Back to the rape case. So try as I might to convince the distraught victim that I would protect her while giving evidence on the stand, and that the Crown had undertaken to pay her airfare, hotel accommodation, and other expenses while the legal proceedings were going on. The thought of having to relive the ordeal, not once, but twice, was just too much for her to handle. In the end, she opted not to give evidence, and a known rapist was allowed to walk free and remain at large. The lesson learned then, and it's one which has been reinforced time and again to me in my years of practice, is that it's not enough to have the law and the facts on your side. Process is a substantial, critical element in its own right. Now, this is well known in the industrial court, for example, where so many employers learn to their detriment that it's not enough to fire somebody for good cause. The way in which you go about it, the process that you use, is just as important, and it will be determinative. Mediators also know about the importance of process, because having the right plan from the outset promotes confidence in the parties appreciate a sense of order and predictability in the session, knowing what will happen and why. So there is value in having a good roadmap to follow, whether it's mediation, arbitration in the industrial court, or court process. A properly designed process does not favor or discriminate against any particular party. A properly designed process is effective and efficient. It should facilitate, not obstruct. 30 plus years ago, in the early 1980s, when I was practicing in our local criminal courts, and I'm talking now in particular when the magistrates' courts were at Nipdeck on Cipriani Boulevard, being involved in a preliminary inquiry was little short of being painful, right? If I said the proceedings moved at a glacial pace, you could accuse me of exaggerating. But that is certainly how it felt. PIs were agonizingly slow. Everyone suffered. It was painful for the magistrate, who, as you have heard, he had to have every exhibit identified and marked, and he had to write everything out in longhand. Section 16B says he shall take or cause to be taken down in writing. Have to read it back to the witness, signed on a deposition, typed up. Huh? When I first started practice, one of my mentors told me that a barrister's holiday was the time between asking the witness a question and getting the answer. That was not what he meant, but I could tell you in the preliminary court, it certainly felt that that made sense. It was painful for witnesses. Now, witnesses are trying to do their civic duty. They're taking time off from work. They might have children to drop to school or to pick up. They have to take time, get permission from their bosses and all this kind of thing. But every time the matter is called, and you're talking about if the accused is on remand and the parties don't agree to an adjourned date, every 28 days the matter is being called, right? So every time the matter is called, until they're released from having to give evidence, they have to be showing up in court. And when they're giving the evidence, you have to speak slowly, because the magistrate trying to write down and capture what they're saying, right? Being repeatedly instructed to speak slowly, in fact, being warned to speak slowly, could throw anybody off their game. So even the quality of their evidence was being diminished. And it would affect their composure and everything. It was painful, too, for the police. I remember going into those courts and you're seeing throngs of police officers milling around all the courthouse precincts, waiting for their names to be called, if at all. Yeah? Time better spent by being out on the field, but trapped like insects on fly paper in an archaic and fog-like process. Painful, too, for the accused, often on remand while the process drags on interminably. Now himself a victim of an unyielding, unsympathetic, and plodding system. But most of all, painful for the victim. Dehumanized by the description, virtual complainant, who besides having to relive the ordeal not once, but twice over, now found to her or his distress that their time is beholden to the state and to the state's agents. Being a witness for the prosecution was not as glamorous as it sounds. Now, this was English 19th century processes and systems in action. Processes and systems in action 100 years later, at a time and a place which bore little or no resemblance to the Victorian age. When preliminary inquiries were first introduced in the United Kingdom, They were hailed as innovative and an improvement to what existed previously. The 19th century Victorian Parliament took action to reform the operations of the judicial system as an outcome of rapid urbanization and the Industrial Revolution. That period, too, saw the introduction of the policeman, in England called bobbies after the Prime Minister, Sir Robert Peel. I had a note somewhere. Yes. So I want to put it in context because the industrial age, the Industrial Revolution, was a turning point in history. It was a change from agrarian to machinery. Well, we are now in the fourth Industrial Revolution. Yeah? We have shifted from machinery to cyber-physical systems, new ways in which technology have become embedded within our societies. We are in the digital age. The PI system is analog. But systems, like motor cars and airplanes, must evolve. They have to change with the times. They cannot be rigid and static. They must be adaptable to the circumstances. And they should always, where possible, make use of appropriate technology. It is a continual process. Good processes, good systems are always evolving. Today in this Senate, we are making and we will be part of legal history. Today we have the unique and distinct honor of playing a role in the evolution of law in Trinidad and Tobago. The PI system was a product of its time, and there was much good to it as a means of getting the state to disclose its case to the defense before trial, as providing a forum where the accused was afforded an opportunity to discover and appreciate the case against him, and in keeping with its main purpose, the committal function, an opportunity to evaluate the evidence and charges to see if there was enough to commit the accused to stand trial before a judge and jury. But today, preliminary inquiries are the poster child of the maxim, the wheels of justice grind slowly. PIs are not good for complex crime. I'm an intellectual property lawyer. It's very hard to deal with that type of matter in a preliminary inquiry. Well, true, there are summary offenses, but it would not be a good fit. Today, the new criminal procedure rules provide robust discovery and disclosure procedures. So the justification for that no longer exists. PIs, in my respectful submission, have become obsolete, if not archaic, a relic of the past which has outlived its usefulness. The PI system served like a funnel. A senior magistrate would sift through the evidence to see if there was enough to go forward. But the funnel was too small to cope with the heavy workload and demands being made on it. The funnel couldn't handle sufficiently all the various strands of evidence which need to come together in a timely and efficient manner. Marshalling and coordinating your witnesses, waiting on forensics to conduct and certify whether the exhibit is really a gun or really drugs. So for today's needs, in the 21st century, PIs are a flawed and poorly designed process. A plodding justice system, clogging up the courts, counterproductive, and perhaps even toxic. What was once a staple of the UK 19th century criminal justice system is now being process re-engineered by this suite of legislation. A suite of legislation which has considered the current demands on the legal system, our legal processes, our legal offices and institutions, our rules, and the participants involved. It treats with searches of aircraft. Trinidad and Tobago is a member of ICAO, the International Civil Aviation Organization. And ICAO allows member states to have power to regulate, including power to implement and maintain security measures. Let's not forget what happened on 9/11. The terrorist attacks on 9/11 were a wake-up call for everybody in aviation to reassess security measures and to develop more robust security systems. So now you can search airplanes for prohibited items such as guns, drugs, and other devices. This legislation allows experts and other relevant persons to accompany the police when conducting searches. Computer experts, accountants, and the like. Well, we already have something like this in the civil jurisdiction with Anton Pillar orders. I have done a number of Anton Pillar orders, and you would have the police there, you would have an independent attorney to supervise and report to the court, but you would have to have with you your experts, because if it is like you're dealing with computer software, counterfeiting, things like that, the ordinary policeman, the ordinary lawyer is not going to be able to discern what to pick up, what to leave behind. So this makes perfect sense to me. This legislation expands on the requirements to the form of a search warrant, which is specified by statute by allowing for more than one premises to be searched on the same warrant, to be able to search a premises more than once, and for searches to be conducted within a certain time frame. I have no problem with this. It provides for photographing and digital recording of seized items. Well, I want to tell you that's a real benefit for the property owner. And less need for storage space in the police stations or where have you. And because photos and digital evidence will now constitute sufficient evidence, it minimizes, if not obviates, the hassles and all the risks attendant to the chain of custody issue. Now, one suggestion I'd like to make. In the copyright law at section 44, there is provision for the use of samples. So you seize a container load of counterfeit DVDs or jerseys. You're not going to tag and mark every single item. You're not going to bring the whole container to the magistrate's court. Section 44 allows for samples to be used. The court need only examine a few specimens of the seized items, and there's a rebuttable presumption that the remaining items are also infringing and unlawful. So maybe that is something we could consider in this legislation as well. It allows for judicial officers in the criminal justice system, registrars, clerks of the court, magistrates, and masters to exercise concurrent jurisdiction. And this will prevent potential gaps or cracks in the system. It allows for the filing of documents electronically. An important feature of life and practice in the 21st century. You know, when I'm asked to talk about how does the CCJ compare with the Privy Council, I says, one is a totally paperless court. One is steeped in 19th century procedures and systems. Paperless is the way to go. It's sustainable development as well. So all told, what we are doing here today with this, which is just part of a suite of legislation, all interconnected, is we are laying a foundation. We are designing a future. We are creating an ecosystem for the criminal justice system in this country. We are seeing with the new criminal procedure rules, better case management. It would have been nice too, another suggestion, if we could have incorporated the Chief Justice's practice direction on defense statement and giving it legislative force. I would have liked to have seen that in the legislation, but we still have the practice direction. Mr. Vice President, the current preliminary inquiry system has become irrelevant and costly to the effective administration of justice. It is not just a bug, it is a nightmare. This legislation will simplify procedures. It will make better use of technology, like the voice recording. I mean, time to get rid of this longhand note-taking. It will make giving evidence less distressing for victims and their families. It will save police officers the time to come to court and testify. It's going to free up limited judicial resources, and it's going to make for speedier trials. The status quo is not an option. Our citizens deserve swift and fair justice, effective and efficient administration. This legislation will modernize the antiquated and inefficient preliminary inquiry process. In a couple of weeks' time, we will see the end of 2019. The 21st century is no longer a teenager. It's a well-established adult in a couple of weeks' time. So it's time for our legislation to grow up. This law will bring us, it's going to leapfrog us into the 21st century. So I wish to compliment all those who have participated in its design, and I am privileged and honored to be a part of this. Thank you.
Senator Thompson-Ahye.
Thank you. Why this bill? We've had this law for a long time. Is it the time when it should be at an end? And if so, why? There is no law that will please everybody. But should it continue? That is a question that we have to ask ourselves. The law as it stands today. Obviously, the Attorney General thinks it should not. And as a voice of the government, one can say the government thinks this bill has seen its last days, this preliminary inquiry, and it should be brought to an end. So we come today, Mr. Vice President, on this bill, the Administration of Justice Indictable Proceedings Amendment Number 3 Bill 2019. And we've heard that we've come here time and time again because we're trying to get it right. There is no doubt that the Attorney General is correct when he says that preliminary inquiries are time-consuming. And persons who are brought before the court will tell you that it is costly. Some defense counsel would prefer that it would remain for the selfish reason is that it would accord them more money. And that's not just old talk, because I once heard a very high-ranking senior defense attorney saying, well, you know, if my submission is accepted, it would be less money for me, so that it would be good if it goes for trial, I'll get more money. That is the reality. So we have the question of the cost, we have the question of the delay, and there are practical reasons why we want trials to be as speedy as possible. Because we know that we're dealing with human beings, we're dealing with evidence, and many times what happens is that evidence, the mind operates in such a way that memories will fade, and that's a very real thing that happens. So sometimes it is thought that the witness is giving trouble when the witness really cannot remember what happened. There are cases also where the matter has taken so long to come to trial that the victim is no longer interested. and finds really and truly, why are you bothering me with this case? So long I forget about that. I want to get on with my life. And sometimes the circumstances that have evolved would cause much more distress because of intervening circumstances. There was a case where an incest was the charge, and the product of the incest, the boy was now almost a teenager and did not want the mother to give evidence against the father, and she was really torn about how she should operate in this case. There was a case of a teacher who had to give evidence in the trial of a child, and she was in such distress every time she had to go to the high court. It was so long after the trial, and she just wanted, of course, to be free of that. So we have an instance now where we're looking at sufficiency of evidence hearing. The evidence is to be assessed, and a determination has to be made. Now, if it is that at the end of the day, the master believes that there is sufficient evidence, the case is sent forward. If the master dismisses it, the DPP can appeal. What if the case is such that the matter should not go forward? Is there provision to appeal that decision of the master as the law now stands? I recall a case where I was appearing in a preliminary inquiry in the Tunapuna court many years ago. And it happened that I put forward a situation of self-defense. And the DPP's representative agreed that we had not negative self-defense, and the magistrate at the time did not want to take the responsibility of discharging the accused, and so that young man, who was 17 years at the time, had to wait 3 years until that matter came on for trial, and then the jury found self-defense had been proved, and therefore he was set free. 3 years he spent waiting because the proper thing did not happen at the end of the preliminary inquiry. Now, the Attorney General has stressed the fact over and over again that it is not magistrates, it is masters, so it's at the high court level. But is that a real advantage? We have in our system a number of magistrates who are very, very experienced. They have been sitting in the court for many years. Not all of the masters, as I understand it, are persons who operate in the magistracy and have that kind of experience. So we have to be very careful about who are the persons who have been selected to deal with these kind of matters, to make sure that we get the best results. Because we don't want a situation where instead of operating in a way that we achieve justice, we do not achieve justice. Now, we know that a question of a speedy trial is a constitutional right, and we all want to make sure that we operate a system where justice comes at the earliest opportunity, because justice delayed, we know, is not just a cliche, it is a fact that justice delayed is justice denied. So we want speedy trials. So we have to make sure that the evidence is assessed, but how do we always ensure that all of the evidence is brought forward by the persons before the court? Because the prosecution office will depend on what the police bring forward in terms of their investigation. So we have to work as well to make sure that the police always do their duty in terms of the evidence that they bring forward to the court, that it is not fabricated evidence. And that's why the question of taping statements by the accused to make sure that the statements were in fact made and not fabricated, that's very important that we get on with doing that to make sure everything is done above board. Now, I have inquired from other jurisdictions as to how this law is operating. And in speaking to Jamaica, to someone at a very high level, the response was, it has been working to some extent very well. But what we have observed is that the backlog has now been transferred to the DPP's office. I have heard the cry of the DPP for a long time in terms of the human resources, in terms of the physical space. So when we implement this legislation, we ought to be sure that everything is in place to assist the DPP to carry out the very onerous responsibilities that he has been faced with. Because many times we find that we put legislation and all of the infrastructure, all of the things are not in tandem. So we find on the one place we're putting a lot of legislation, but then the implementation, because everything is, is not prepared, causes problems. So therefore we can't pat our backs and say, we've put this law in place, we've put this law in place, if we have not put in place all the attendant support systems. So we must have a properly resourced Director of Public Prosecutions Department so that he can carry out his job, and we must have persons at the master's level who are properly well experienced and properly trained to do the job that they have to do. Now, when Jamaica brought their legislation into being, what they did at the same time is to implement another piece of legislation. And that piece of legislation was the Jamaica Law Reform Miscellaneous Amendments Restorative Justice Act 2016, which introduced restorative justice at various steps of the proceedings. Trinidad and Tobago has been talking restorative justice for many years. We have heard all the support, all the platitudes, all the praise being showered at Wayne Chance on the occasion of during his life and on the occasion of his death. High officials attended his funeral. And Wayne Chance, his mantra was restorative justice. Many times we would discuss together, and I would always tell him, you don't have a proper concept of what is restorative justice, because you still have this punitive mindset. But his heart was in the right place. And he was trying to send a message that not only the offender, although he emphasized the offender, but also the victim, restorative justice says, and the community must be involved. So what Jamaica did is instituted restorative justice at the level of both before court proceedings commenced, while you're before the court, before the trial commenced, while the trial was going on, and even at the end of the trial. Even at the end of the trial, when you come to stage of sentencing, that you can still have the matter being taken out of court, sent to a restorative justice session, so that the offender, the victim, and the community would be involved. Because if we're talking about getting people out of prison, if we're talking about healing, we ought to be talking restorative justice. But for some reason, Trinidad and Tobago has been very wary of even attempting the holistic picture of restorative justice. So we have portions of it. We have victim support, which deals with the victim. We have situations where we help the offender. We have the drug treatment court and so on. But we do not have the holistic picture of restorative justice. And if we want to bring about a changed community, if we want to bring about healing in the community, then we must be looking at instituting restorative justice for 2020. Now, the Attorney General said this morning that I would be pleased about a proposed amendment, which is Clause 15. I'm not at all happy with that. So that is an error on his part. He has misread my thinking on this issue. Because what Clause 15 is doing is amending Section 21 to reduce the age of children who will be permitted to give unsworn statements from 14 years to 10 years. Now, we can't look at that in isolation. We must look at this clause in relation to the fact of the age of criminal responsibility, which this government, like all the governments before, stubbornly refuses to change. So we are in this scandalous position where the age of criminal responsibility in Trinidad and Tobago is 7. But in Jamaica, where it is 12, they have not reduced the age for children to give unsworn evidence. So it remains at 14. And this is important because if you're giving evidence, you're allowed to give evidence on sworn statement below the age of 14, so you want to raise it to 10, to lower it to 10 years. If it is found that you have given a statement or you have made a deposition, a child, which is false in fact, then that child can be prosecuted. So we can prosecute, whereas in Jamaica, you do not prosecute children under 12. In Trinidad and Tobago, we can prosecute children. So why would we want to lower that age and put the children at risk? So my recommendation is that we do not lower that age, but keep it as it is. And I just want to point out that the section of the law that we quoted in the bill essentials and in the bill itself is incorrect, because when one looks at, I think it's, you said section 91 or so, that deals with the compulsory age for child labor, and the one that deals with giving evidence, a child of tender years, which is interpreted a child under 14 years, which we're seeking to change to 10 years, is really section 98 of our present Children Act. So we need to look at that and correct it in our bill. When we're looking at reform of the criminal justice system, we ought to take a holistic picture. And over the years, we have been talking about doing so many things. And these many things have really not been happening. We have been doing other things that we have not been speaking about before. For many years, we've been talking about a parole bill. And during the time when we've met with prisoners, I'm sure the Minister of National Security, the Attorney General, and so on, we keep hearing about people, even from the Commissioner of Prisons, who really have been model prisoners over the years, who they take out sometimes into the community to talk, and even in schools, to talk to members of the community and schools. We're in charge to do a lot of that, and some of his colleagues who are still inside. So they talk about what happened to them to cause them to get involved in crime. And they have been very much, doing a lot of good things in the community. We bring them out sometimes when we want to show the world that, we're doing good things in prison. Look, they're painting beautiful pictures. So they have artwork going on. They're doing things in the library. They're doing things, they are winning competitions in public speaking and debating. So many good things are happening in the prison. These people you hear, many times when I meet them at different fora, that they have been exemplary prisoners. Why are they not being released? Why are they not being released? You hear the Commissioner of Prison time and time again. So when we are looking at all of these things, why haven't we looked at instituting some system like that? What is the reason for it? What is keeping us back? What is keeping us back from instituting restorative justice? So there are many things that we can do, which would not be causing us money, but what would help to relieve the prison population, and yet we cherry pick what we want to deal with at a particular point in time, at this point in time. Why are the other things are not seemingly politically correct for us to do? So I would ask that we look holistically at the whole system of our prisons and our criminal justice system and see what can we do as a population that is committed to reducing the prison population, that is committed to reintegration, and to making this a better and a safer place for all of us. So at the end of the day, we will have our bill, but we will not feel totally satisfied that we have done all that we can do. So I'm asking for a parole system. I'm asking for us to look at the age of criminal responsibility, which is not only the lowest in the Caribbean, but the lowest in the world. And as I told the Attorney General, when he first got this position, do not let that be your legacy, that you leave. And I'm not saying that you're leaving the position of Attorney General, but do not let it happen that at the end of the day, this important reform in child law is not brought to fruition. Thank you.
Senator Thomas.
Mr. Vice President, thank you for the opportunity to contribute to this important piece of legislation, the Administration of Justice Entitled Proceedings Amendment Act number 3, Bill number 3 of 2019. As I rise to make a contribution on this piece of legislation, I would like to commend sincerely Senator Anthony Vieira, because he could not have said it better, and he could not have given a better piece of disposition on what this piece of legislation is intended to do and why is it so important at this point in time. And I'm saying this, members of this House, because as a young boy growing up in Trinidad and Tobago, I have witnessed every tabloid in this country, everyone, Express, Guardian, Newsday, Evening News, Bomb, Punch, everyone during the era of the 1980s, 1990s, criticized government go, government come on this criminal judicial system that we have. Everyone. All governments were embarrassed. NAR, PNM, UNC, call the names. They went through the rigors of our criminal justice system. Nobody did anything. All our laudable and eloquent and distinguished lawyers who sit as Attorney General, from the Richardsons to the Maraj to our own, what's his name? our senior, who was the senior counsel? Mr. Jeremy. All of them. While this torn in the society continues for years, nobody did anything. And I want to thank the Attorney General today for having the testicular fortitude to sit and do at least one thing to try and address this system. This has been a thorn in this society for as long as I could remember myself, even before I engaged in the practice of law. Mr. Vice President, this question of preliminary inquiry is one that has always engaged my attention long before my initiation into the legal profession. When I started to study law, it was as a result of a friend of my father, whom I was told had been arrested and charged for wounding with intent to cause grievous bodily harm. I was told that this gentleman would have gone to assist an old lady, a neighbor, sometime in the night when somebody broke into a house. And not knowing who the person was, after he got close to the person, he would have used, in those days in the country, planners. And instead of plannasing him, would have had the wrong side of the cutlass.
Senator, let me just,
Please.
at this point, caution you on the use of certain words
Yes, please.
that might be deemed unparliamentary.
With the flat side of the cutlass. But instead of doing that, he would have hit him with the edge and would have caused serious damage to the face and chest. But he was a good friend of my father, very good friend of my father. And for years, I will hear my father complain that Colin can't get at his day in court. And he would dress up and go to the Princestown court on every occasion. Every month he used to be there. He would dress up and go just to see what happened. And he will complain. Now, it really wasn't my business because as a child, I really don't concern myself with who do what and who didn't do. But one day faced with the reality of having to choose a topic to write for an elective, I think in those days was Law and Society. This ran back to me and I decided to actually research the paper on this issue of indictable offenses and preliminary inquiry. And Mr. Vice President, when I went to my cupboard where I store my books, I actually found it, and I have it with me. And I would want to seek the permission of this Honorable House to read some excerpt from it. But I tried getting some information from another close friend of my father because he's now deceased. And he told me that it took this gentleman, Colin, 16 years to get a day when the court pronounced that he was discharged. And Mr. Vice President, when issues as this particular piece of legislation raises its head in society for so long, whatever initiatives that one takes to try and address the issue would always be a welcome sign. And for all of us who sit here, whether we're on the opposition side, the independent side, or government side, this should really be a day of redemption for us. At least something is being done so that there is a start, and we hope and wish it all the best so that we can have some degree of ease, because it is not just us. It is the public confidence in the criminal justice system that I think that matters most. And if I may just look at parts of what this thesis would have actually said. It started off by saying that the complicated process of criminal justice is divided into different parts, responsibility for which is separately vested in various participants upon whom the criminal law relies for vindication. Essentially, the administration of criminal justice system is a sequential process performed by agents and agencies of government, each having clearly defined functions. Thus, its ultimate success depends upon an orderly progression of events activated and operated by agencies of government, inclusive of the police, the Director of Public Prosecutions, the magistrates and judges. Members of the public and defense attorneys engaged in private practice are all active participants in the criminal justice process. In aggregate, they make up the administration of criminal justice system. Delay in the administration of justice arises more often where an accused is charged with an indictable offense. An indictable offense is one that lies for any treason and for any other offense other than an offense over which courts of summary jurisdiction have exclusive jurisdiction. The process commences with the police, who on the basis of prima facie evidence arrests and charges the accused for the commission of an indictable offense. The police, after assessing the relevant evidence, sends the criminal file to the office of the DPP. The Director of Public Prosecution rationalizes the evidence and prepares the case for the preliminary inquiry to be heard before the magistrate. Where a person is charged with an indictable offense is brought to a magistrate court, the court must hold a preliminary inquiry for the purpose of determining whether there is sufficient evidence to put the accused on trial for the alleged indictable offense. Once the court is satisfied that the prosecution has made out a prima facie case against the accused, the magistrate would commit the accused to stand trial before a judge. This process, as far as it operates in Trinidad and Tobago, is seldom an expeditious one. Since the 1960s, the courts of Trinidad and Tobago have been faced with the perennial problem of a backlog of indictable offenses cases pending trial. Although some attempts have been made by the authorities to reduce the backlog, only marginal success has been achieved. The situation as it stood at the commencement of the decades of the 1990s was described by Chief Justice Michael de la Bastide as nothing short of a national scandal. And this, he said while making an address to the judiciary on the occasion of the opening of the 1995-1996 law term. He noted that the increase in the volume of cases had grown to such a monumental proportion that up to the present time, the delays in the determination of cases has also become caustic. I have a problem with the pronunciation of this word, but it is Grotesque. Grotesque. Presently, it is usual for committal proceedings to take as long as 2 years to be completed. but a further wait of 18 months between committal and trial is certainly an exaggeration. And this is in 1995, 96. One of the fundamental qualities of the administration of criminal justice system in England, from which English-speaking Commonwealth Caribbean has fashioned so much of its legal principle, is that the judicial determination of the criminal offense for which an accused has been charged must be pursued expeditiously. Further, any appeal against conviction is heard promptly, and any appeal procedure is quickly exhausted. Ultimately, such virtuous quality is atypical to the jurisdiction of Trinidad and Tobago. In Trinidad and Tobago, there is no express constitutional right to a speedy trial. There is no constitutional right to a speedy trial within a reasonable time. And members, the reason why I have read that part of the thesis is because the real problem that faces this country as far as the criminal justice system is concerned is not really that it is the preliminary inquiry is oblivious. If it is expeditiously done, it is quite okay. And therefore, finding another avenue, finding somehow some method by which we can exercise these trials, because they're important, differently, to make it more expeditious, it is something that I think this House should support at all costs. And I just wanted to indicate to the House that this is an opportunity for us as a society to make this particular area of law a more amicable and amenable place so that members of the society could benefit. I want to thank you.
Thank you, Madam President. Thank you, Madam President. As I rise to join in this debate on the Administration of Justice Indictable Proceedings Amendment Number 3 Bill 2019, I came here prepared, like Senator Cummings, I think, to talk about the need to improve the administration of justice for the people of Trinidad and Tobago. And I understood from the framing set out by the Attorney General that the intent of this piece of legislation, as indeed the ones that would have gone before, would be to have an improved justice system overall for the people of Trinidad and Tobago. And time again, the Attorney General comes before the Parliament and gives to us the list of what he would indeed consider to be his achievements over his tenure. And we would be told that X number of pieces of legislation would have been passed, and you have to get started, you have to do things and start somewhere. And once you get started, things will fall into place. So I listened to Senator Cummings as he raised his points about the people of Trinidad and Tobago deserving better, and that we ought to welcome this move. But here we are in 2019, the end of 2019, facing the end of the tenure of this administration, and it is time for them to account. So when you come after a certain number of years and you say, you've done X, Y, and Z, the time to account to the people is now to say, this is how it has improved the lives of persons in a measurable way. And if in piloting pieces of legislation that adds to legislation that has gone before, you are not able to tell us, this is how the system has improved, this is the way the people are benefiting now, then I would consider that to be a failure in terms of the accounting to the people of Trinidad and Tobago. Senator Cummings said that this is the time for there's not always chicken licking, and that we ought not to always be running around talking about the flaws in the bill, and you know, it's a misunderstanding of what the role of the opposition is. The opposition must hold the government to account. And
Senator Haynes, please, members, we have been proceeding fairly quietly in this chamber with the debate, and I'd like it to continue along that line. Continue, Senator Haynes.
Thank you, Madam President. So, Madam President, it is indeed we have a role to hold the government to account. And my contribution here today is in that backdrop, Madam President. Because as I prepared, and as we were thinking about the justice system and its effectiveness, I decided to approach the research for today in terms of what would have been done over the last 4 years and what was the measurable impact thus far. And I came upon a report from the Joint Select Committee on Finance and Legal Affairs, Madam President. Now, this committee met in the session between 2016 and 2017. So that predates my tenure in the Senate and some of us on this bench. But what it shows is that this conversation, and the Joint Select Committee was decided to investigate criminal case flow management in the High Court. This is in 2016. And if you would permit me to read just a little from the report in terms of what the inquiry was supposed to do, Madam President. And the committee, and I'm quoting here from the report, the inquiry process involved gathering and collating oral and written evidence with respect to the issue from primary and secondary stakeholders as well as from the public. And they spoke about, in this regard, the committee reviewed evidence from several major stakeholders in the criminal justice system, including the Director of Public Prosecutions, officials of the Legal Aid and Advisory Authority, and the Ministry of the Attorney General and Legal Affairs, and the Inspector of Prisons. And this is from the executive summary. From the evidence, the committee took particular note of what, in its view, were the significant issues, developments concerning criminal case flow management in the High Court. And these were as follows. The disparity between the small number of criminal practitioners and the volume of the criminal cases in the assizes, the challenges faced by the Director of Public Prosecutions in the recruitment and retention of State Counsel, the security risks faced by prosecutors and their families due to their involvement in criminal cases, the need for building and human resource and the technical capacity of the DPP's office, the increasing numbers of prisoners being held on remand for extended periods, and the increasing acts of violence done by persons on remand, the failure of police officers to provide disclosure and other information in a timely manner, the capacity of the LAAA had been increased so much that there was now in-house counsel who were briefed on criminal matters, and the inability of the LAAA to have attorneys sent to remote magisterial courts and also make arrangements for complex trials. And, Madam President, I went to the Ministry of the Attorney General and Legal Affairs, issued their response to the report by the committee. And I thought that was instructive because as the Attorney General comes before us and asks for support on a piece of legislation to improve the justice system, part of that, I think, is important in answering the questions because certain promises would have been made as far back as 2017. And in reporting, you need to tell us where we're at with some of these promises that would have been made. So the Ministry of Attorney General responded in terms of the recruitment at the DPP's office. And and they noted in that regard, concerns raised, it's that the Judicial, Legal and Services Commission is currently conducting interviews for 33 state councils at the positions, and that the JLSC also advertised for positions of state councils and had 5 appointments to these positions were anticipated. And so while we're discussing legislation and the legislative backdrop of it, the Attorney General could quite easily tell us what's the state of recruitment at the DPP office, and what is currently being done or what has been done since this report and this statement in Parliament in 2017. So we are full 2 years later. What would have been done? And then, given what they would have done, what's the impact on the people of Trinidad and Tobago? Because if you can't answer those questions, then you're just doing things without really trying to impact people, because you're not measuring anything, you're not checking to see if what you're doing is working. The Attorney General reported in terms of financial autonomy for the DPP's office and said they were currently reviewing the situation, especially in view of a move towards more financial autonomy for the judiciary, and it will require cabinet consideration for proposals of any such policy. In the interim, the Ministry of the Attorney General and Legal Affairs is undertaking a comprehensive review of interdependent structures across the ministry. So I asked the Attorney General in his wind-up today, because all of these things impact the criminal case flow management and will directly impact the people of Trinidad and Tobago. So I think the Attorney General, in asking for anybody to support a piece of legislation, could tell us where he's at with the things that they would have reported on in 2017. And then we got to the physical expansion of the office of the DPP. The committee commented that the pace at which the process of the expansion of the DPP office, the office of the DPP was moving, and the status of the matter is as follows. South Office. Feedback is awaited from the DPP on the draft layout of the space. Port of Spain. Feedback is awaited from the DPP. And you see, Madam President, this is where Trinidad and Tobago really gets fed up. Because you come to the Parliament and you're talking about legislation, and ministers come and report, and then years go by and nothing happens, and then nobody's checking on the report. And so it seems a lot like everybody's wasting time, and nobody's interested in doing the work of improvement. You see, I went through to look at all of the things that the Ministry of the Attorney General promised that they would be doing. And interesting in this bit, because the committee noted that there was an inability to access counsel, so public defenders. And the Ministry of the Attorney General in 2017 said that they had embarked upon discussion with local, regional, and international partners geared towards the creation of a public defender system, which proposes to create the establishment that would house salaried defense attorneys who would be appointed to criminal matters to share the volume of matters currently engaging the attention of private criminal attorneys. Now, Madam President, this would have been something that, had they done it, they could name as an achievement 2019. But you see, when Senator Hussein said that they were committed to a lot of talk, and so you'll come here and pass pieces of legislation and talk and talk and talk, but the actual work to get things done is missing. He's right. And then I noted further down, and I asked the recommendation that there be fixed penalty for certain summary offenses. And in 2017, the Attorney General said, by way of ministerial statement, that a draft bill, summary offenses, fixed penalty bill, had been developed to give effect to this initiative, and the policy paper for the bill was before the Law Reform Commission. And it is intended that the legislation will be brought before Parliament within the current session of Parliament. That's 2017, Madam President. And I checked back, and none of this had been done, was not laid before the Parliament. Now, Madam President, you see, when you come and you bring the bill before us, and it goes to the House of Representatives on Monday, and then it comes to us on Wednesday, and you tell us this is a cure for the ills of the judicial system, and then you tell us that once passed, it's some sort of cure. But we had a joint select committee that this parliament established that went through the evidence, met with stakeholders, and gave certain recommendations. The Attorney General answering those recommendations, and then we see no action or reporting on those recommendations, but we see legislation coming before us time and time again, saying this is the cure to the ill. Madam President, no wonder the population is skeptical. Because as we speak here today, concerns raised on the last occasion with this bill about the state of affairs in Princestown with respect to persons still having to access the Rio Claro Magistrates Court, that still exists today, Madam President. And so, as we discuss things, the disparity between what is done here and what is felt outside by the people of Trinidad and Tobago is a large gap. So you tell us time and time again that the legislation that we will pass here and that will be implemented by January 2020, coming soon, would fix the problems that, as Senator Thomas indicated, existed for many years. And then you wonder why we're skeptical. And you say that the opposition is opposing for opposing's sake. But what we're saying is that we're holding you to account as the government of the Republic of Trinidad and Tobago, that if you have a mandate to improve the lives of citizens, you ought to do so, and not just come and talk about it time and time again. Now, Madam President, as persons would have noted before, this has been a topic that has been in the public domain for quite some time. And the committee report showed us that vast majority of persons do not believe that legislation is the fix, that there are simple policy cures, that there are actionable items that can be taken now that can assist in fixing the problem. But we have a government that is committed to only taking a paper approach or a legislative approach to any problem you face, the problem of crime and criminality. Anything we're facing in Trinidad and Tobago, they tell us they pass a piece of legislation and that will fix it, and there's no implementation anywhere in the spectrum at all. And therefore, we will constantly have the problem and we'll constantly have a conversation, and the Attorney General will tell us time to stop talking is now and we must act, failing to realize that the very action that the action they are talking about is talking. They are talking about coming here to pass legislation and then doing nothing with it beyond that.
You've been speaking for a little while now, but you have been sort of going in cycles on the same issue. So I need for you to move on to deal with other issues if there are any to be dealt with by you.
Thank you, Madam President. But I was actually closing my contribution at that time, Madam President. But I appreciate your guidance. I really was concluding. And because, like I said, what I came here to speak about was that there was a report laid in this Parliament that raised certain concerns, raised recommendations. The Attorney General responded many years ago to those recommendations, and then there's been no accountability since then. So if you're Interested in people of Trinidad and Tobago, do the work necessary to fix the system. And I thank you.
Senator Deyalsingh.
Thank you, Madam President, for allowing me to partake in the discussion on the bill to an act to amend the Administration of Justice Indictable Proceeding Act 2011. Madam President, it's since 1960, I think Lord Devlin had indicated, he described this system, this preliminary inquiries, and as an ossified form of regulations under which we labor. So since 1960, the judicial system, in the UK have recognized, listen, we need to move on, we need to quicken, we need to have that pace of justice move on. And I'm looking at the fact that, the preliminary inquiries, we know it is important, it has its importance in knowing a case, probing a case to know if to dismiss it, if there's a prima facie case to go on with. And all those are elements that was very, very important in carrying a case forward, to know if you have that evidence to go forward or dismiss it. And even in certain instances, this would have even dismissed cases where probably police were fabricating evidence, or there's not enough evidence to go. You just wanted to go after someone. So I'm saying, Madam President, we've all known that this delays in the judicial system. It is mentioned here by some attorneys here that this is something long overdue. And we have known and we have seen even in the civil system when there were changes. I mean, the whole system in the civil courts that has been changed. I mean, there were opposition when it came. Those changes were suggested as the Attorney General suggested. But eventually we saw the benefits of those changes in the civil cases. And Madam President, this changes in this legislation, I think it's quite in 1997. Attempts were made to put changes into this, and then 2014 we saw also, attempts were made to see if we could dismiss this preliminary inquiries. Madam President, I am the first to say if we could improve the system, it will eventually help with the delays and the frustration of the persons who have to go to court for 20 years, sometimes as our Senator Sipasat said, sometimes 20 years cases are going on for. And obviously there's a need to improve the system, and I see this as a commendable need. Economically, it's not good for persons who have to pay attorneys. I mean, the attorneys may benefit, but at least the pockets on the persons now again would help. So therefore, what I'm saying, we well know justice delayed is justice denied, but justice rushed can also lead to rights denied. And this is what we have to be careful for. And as Senator Saddam Hussein mentioned that it's rushed, we come here, we're rushing this, the Attorney General is rushing this, he comes at a fast pace, and I have to say, well, we are looking at the PACE Act of the UK, so I'm thinking probably because of that he wants to have this great pace into getting this going. But the rush is there, and the Attorney General came with this today at this sitting, and I'm saying that he probably realizes he has to get certain things in order before January next year. And again, I could commend that. So I could commend that, and I'm thinking it will definitely help the frustration of persons who have to wait, and I mentioned the economic benefit. However, what I would like to mention that, I would like to support measures to fast-track cases. I would like to support measures to give that ease. But I also have to look at the fact that, could citizens' rights be somehow affected by any sort of legislation that we are going to rush? And a few questions I asked myself, Madam President. I asked myself, when you're looking at this piece of legislation, you're looking especially at Clause 5, which looks at the warrants you're given warrants, you're giving police officers greater leeway. I asked myself a few questions. Do the population or the majority of the people trust police? And I have to say, I must say, I will think not, because there are a lot of cases where people may not want to come forward with cases. We have seen even the Commissioner of Police want to implement lie detector tests on his police officers. I asked myself, has police been acting sometimes, abusing their power? And I said yes, because their evidence occurs. Can abuse continue, or could the abuse be extended in this piece of legislation? And I think it can. And this is where I have a little concern, especially with Clause 5. And you see, so when I looked at Clause 5, I think there is an element there, that piece of legislation, that can allow the police officers to continue, may continue to abuse their power, or individuals. And, people may say, have there been abuse? And there have been abuses that we have seen. And even Senator Choate mentioned that certain safeguards should be put in place. And she mentioned the safeguards, and as an esteemed attorney, I support these safeguards, and I think she needs, the fact that she mentioned these safeguards, it is really a need, I think, that we have to make sure that these safeguards are in place. So I think that I see deficiencies in the system, but I also think that it is dangerous and unfair to people if we are giving more powers to the police, where we have not put mechanism in place to make sure we can stop any misgivings that occurred in the past. I see it as a widening of powers of the police to give these warrants that could further traumatize people. And we have not attempted to look at ways that we could prevent any sort of abuse. So I would have rather that we have come with something like a police reform bill first. Some sort of bill where we could have looked at the police officers, how we could curb abuse, how we could prevent this, and then I would then have a little level of comfort after to give them that additional powers. So, Madam Vice President, imagine getting up you hear a loud noise in your home, your door break open, you see a gun at your face, a strange dog in your bedroom, and your persons in your house causing a disruption. These are real-life instances that happened. These are real-life instances, Madam President, that you see persons who have had that abuse, of people, police invading their homes. They undergo what you call anxiety attack, panic attacks after, acute stress disorder after. And I have patients who, there's a lady from Bagatelle who actually got a heart attack after police broke down the door, I think it was 2 o'clock in the morning, to go after her son. She got a heart attack. And things like that, even though you have nice pieces of legislation, you have to look at the human element of it, how it can affect persons, probably even their neighbors, probably even the neighborhood, probably even their business. So therefore, when I look at persons who, because one of my colleagues mentioned that the incidents in Gulfview, certain people after that incident, there's a certain individual who right now have something called post-traumatic stress. Anytime she sees a police officer, hears a siren, her whole life has changed. And this is something that we have to look at. We have to look at widening powers, but if you're widening the powers, you have to put things in place to prevent abuse. Those people are suffering, Madam President, and I think that we have to be very careful. I remember cases before, Madam President, the Chief Justice had warrants, executed on him, the late Chief Justice. We had a media house again, warrants were executed. Even MP, Mr. Sadiq Bash, I think his home was water tank, things were found in his water tanks. So even though you had that, you see warrants could be instituted from all persons, any person, no matter what walk of life. I remember even a former Speaker of the House was under house arrest. There wasn't a warrant in that case, but what I'm saying, a convoy of police officers had to go to a home. So the effect of police coming to your home, serving warrants, it's again a traumatic event. And those persons who are homes are if you give these warrants willy-nilly, persons who are persons who have also been served warrants, they are stigmatized. People look at them and want to know, are they involved in drugs, guns? And those persons here now are telling me that, sometimes their whole face in the community. So we have to be careful, and I just want to belabor that point. Madam President, I would, this piece of paper called a warrant has a great responsibility. It's not just a little, it's a paper that can destroy lives. It's a paper that can make people undergo trauma for years. And Madam President, we were here recently discussing the marijuana legislation. And in the marijuana legislation, the Attorney General mentioned that a lot of those persons incarcerated in remand yard are young Afro-Trinidadian males who cannot afford bail, and that this whole idea of decriminalizing marijuana, we have to look at that element of that population who in his when he mentioned, somehow were not able to afford bail, they were there, they were languishing in jail, and he brought in that point. And as the same way, Madam President, I want to bring to the attention that a lot of those cases where police break into people's homes, go into people's homes with warrants, with false warrants sometimes, are really the Afro-Trinidadian individuals who suffer, who actually are there asking, you know, what is police doing? How could we get any sort of a justice in this? And I would like to quote Loop News, 10th of November, 2017, where this Loop News actually spoke of a video where it showed heavily armed police trying to gain entry into a woman's home while she frantically requests to see the address of the warrant several times. So,
You've been speaking for a little over 10 minutes now, and you've dealt with this issue of the warrant. And from what I understand you to say, that you think it's something that should be looked at, that there should be safeguards. But I would ask you now to move on to other points that are relevant to the bill. Yeah?
thank you, Madam President. But 2 points I just wanted to elaborate from this piece article. One point, I must say that it mentioned Senior Superintendent Radcliffe Boxill assured the public that they would be compensated for damages once they could prove that the damage was done by the police. And he made the comments at a town meeting in Laventille where residents complained about police kicking down their doors in search of illegal items. And you see, Boxill said persons should take photographic evidence of the damage and document the police officer's name, vehicle numbers, and any other relevant information. Madam President, what I'm trying to come at is, in any piece of legislation where we are going now to increase the powers of the police, I am not seeing a level where we could increase any sort of safeguard or compensation to the persons who may have been think they may be abused by the police officers. And even the same article, I quote Laventille West MP Fitzgerald Haynes also stated that a fund should be set up by government for compensation to be made to persons whose property is damaged by the police in the conduct of their duties. So the point I wanted to make, yes, people are getting, what they claim abused by the police officers. They may be concerned that their articles are damaged, their houses are damaged, their doors are kicked down, and they are traumatized. And I'm saying the MP had recommended a fund be set up, and somehow I'm thinking, if we are going to look at the administration of justice to help persons, to help people get quicker justice, we should also have something in there. Taking his recommendation and Mr. Boxill's recommendation, that something in there should be there to protect the rights of the individuals, or even to give them that right that they can seek compensation. And Madam President, I want to quote Trinidad Guardian, where an article by Mark Bassant and Radica De Silva, 3rd of May 2019, where it spoke of the issue where there was a chap called Ravi Dinanath, where he actually claimed, I had no idea that he would come to my home next. And
Deyalsingh, I think you are repeating the same point with reference to different newspaper articles, but it's the same point that you have made. So I really do think that you should move on to other points. You are the 11th speaker in this debate, so I need for you to cover some other areas, because I think you have, in your contribution, you've covered this substantially, yeah?
Okay. Thank you, Madam President. So it was mainly to belabor the fact that those persons claimed that they were traumatized, and there was even a teacher called Minty Ishmael from NAPS who her house was broken into. And all of those incidents, we have no idea if those people got compensation. So I'm thinking somehow we have to look at that level of compensation to be given. What I would like to look at, Madam President, is the fact that when I looked at this bill on Clause 5, and I looked at the fact that, Clause 5, we are looking at, of the bill, seeks to insert the following 3 new subsections after existing subsection 5 on as follows. And in subsection 1A, it provides that a search warrant can authorize the search of one or more premises as specified in the warrant. The search can authorize the search of any occupied premises controlled by the person specified in the search. Madam President, when I looked at this, I looked at the end of that where it also stated that the search warrant also should be could also be given to all the various premises occupied and controlled by the suspect, which may need to be searched. I have a problem where, you're looking and, you're going after certain persons' properties, but you're not specifically naming which properties you're going to. And I think the widening of these powers, Madam President, is something that I find that, somehow I'm not too comfortable with it, given the present climate, given the complaints that I attempted to read into this discussion, the claims about cops raid, 7 Gulfview mansions. I mean, when I wanted to bring in these, it's actually show that the level of persons in Gulfview. Yes, sure.
Saying, I'm sorry, but I have to ask you, you've made reference to these things already, and you've made your points, and the points are fairly clear. So what I'm asking you to do now is to move on to other points.
Sure.
Because you've spoken about this already, and you've spoken at length about Clause 5. So perhaps you can move on to other clauses on which you wish to present.
Sure. So, Madam President, I thank you, and I am guided. As I said, I have some hesitation in giving my support to this, especially since I've seen people traumatized by police abuse. Now, I understand the police may want to act and may need more powers, but we have to look at protecting also the rights of the citizen. I also make mention of subsection 1B, which provides that one search warrant can authorize the search of a premise on multiple occasions. Again, I have a great, some problems with that, multiple occasions. So therefore, you may be giving police officers that power to come into your place, and then you don't know when next they can come in. They go to a place, they can come in next week, they can come in the day after, and I think this is not in keeping, I think, with a good practice in the sense that, especially in our climate, that we have seen misuse. And you see, Madam President, they said if the master is satisfied that it is necessary to authorize multiple searches to achieve the intended purposes for which a search warrant was issued. Well, I understand what the police officers may want to do. They may want to go into a place, they may not find anything, and they may want to go back to a place to go back to that same place. But you see, in the past, I have seen cases where, I think it was mentioned on the other side, that in certain court cases, certain persons may want to go down San Fernando in the High Court there because they may have an affiliation with some judicial figures there. Similarly, police officers in their courts may look at a magistrate and may decide, well, this magistrate I will go, I know that magistrate, and he will, anything I tell him at oath, he will just give me that permission. So therefore, if there's some sort of collusion between the magistrate or a magistrate serving in an area. So.
Senator Deyalsingh, I don't think it is proper to say that at all. A magistrate is performing judicial functions, and I therefore don't think that you should be casting any sort of aspersions on the administration of justice. So can I ask you, please, to desist from that and to move on?
Sure. Thank you. Madam President. But Madam President, if we looked at Clause 16, where you actually see that where a master finds insufficient evidence to establish a prima facie case and discharges it, it still allows for the DPP now to override the magistrate, probably for whatever reason, and come in and ask the judge now to say, well, I don't think the magistrate made a wise decision or for whatever reason. And it gives the DPP a discretion now to I don't know if it's a mistrust of the magistrate or mistrust of what proceedings, but allow that DPP to go to a judge to get an overturn in that decision. So what I'm saying, Madam President, I think a good situation should be if you are want to go to a premises on multiple occasions, it may be beneficial to go to different masters or different magistrates, or it may be beneficial to have a pool of judicial figures you can go to say that there are about 5 names and I could choose whichever name, so therefore I can pick up a name to say, because even in the court cases now, I think there's a case, that the judges will, according, they are actually assigned cases. So therefore I'm thinking that probably it should not be one magistrate to one area, but it should be a variety of magistrates who you can choose to go. That police officer can go to to get that, warrant. So I am not comfortable, I'm saying, with that subsection 1C, which gives limited or unlimited searches, multiple searches. Madam President, I also want to look at clause 10, which seeks to look at the current jurisdiction of the masters and the magistrates, where clause 10 of the bill seeks to amend section 10 to authorize the Register of the Supreme Court to exercise the same concurrent jurisdiction that magistrates, magistrate registers, and clerks of the court exercise with masters. So again, I'm saying that there are a pool of persons who can actually, be available when a police is applying for bail, that I'm thinking he can go to different persons in that pool rather than one magistrate or one master in a certain area. And again, one of my colleagues, Senator Ahye, mentioned the fact that, you may get some masters and they may not have that level of experience as some of the magistrates. So sometimes it's probably advisable not to just have one master, one police, but a pool. As I look at clause 5 again, Madam President, subsection 6A, which provides that the Commissioner of Police can authorize that anything seized upon execution of the search warrant can be photographed or digitally recorded. I think this is a very welcome piece of legislation. So again, we have seen sometimes graveyard of cars in certain areas. We have seen cars parked up, which again, theft of articles from the cars. We have seen pollution. We have seen vermin living in the cars. So I'm thinking to get rid of this certainly is a welcome move. And I think we are looking at environmental laws. I think this is something that can help clear up the environment. So at least this is something I commend. And I might also want to say that when we are looking at digitalizing and photographing evidence, Madam President, I also want to make reference to the fact that if we are going this way, we have a lot of claims of people claiming that they are being abused. And even on one of the newspaper article I mentioned, where the Superintendent Boxill mentioned that if you have your things damaged, take evidence, take photos of it. I am thinking, to prevent any sort of abuse, couldn't we somehow in the law put in body cams for these police officers? So when they are going into every single room, they are not, even though our police officers, people may have claims, they are going to plant evidence, they're going to plant a packet. So I'm thinking somewhere along this legislation, if you want to widen the powers, they are going into your house, body cams must show every single room they are going to. As well as, Madam President, I am saying, in the past, when persons try to videotape the police officers in their activities, they were told sometimes that they should not videotape the police in their activities, that it's against the law. And I'm saying somehow we have to change that or get some sort of directive that if somebody comes into my place, and yes, I'm thinking if we have the body cams and the police that we could refer back to, but I'm thinking we should also have that level where I could videotape their activities, searching room to room. And this is something as an additional level of comfort, I think, that, that police officers wouldn't look at you and say, hey, you cannot videotape us in our activities. This is wrong. I'm thinking you're coming into my home. I should have every right to videotape this, to be able to show after if you're using excessive force, to be able to show after if you are planted anything. And I'm thinking somehow in this piece of legislation, if we are going to digitalize and modernize, somehow we have to digitalize and modernize to protect the rights of the individuals too. They allow the persons to be able to video for themselves, and have clear directives for that. So, Madam President, I have to also commend the AG for Clause 13 of the bill, which actually sought to amend Section 19. And previously, when this bill came, we got the impression that to establish the prima facie case would not be there. But this clearly states here now that there's, it seeks to amend Section 19 to allow the master to determine whether there's sufficient evidence to establish a prima facie case of an indictable offense at a sufficiency hearing. And the master can also determine when it would be appropriate for a sufficiency hearing to not be conducted in open court. So this is something commendable because it brings in that level of comfort that you are getting a case that may be able to go forward. So, Madam President, all in all, I am for the fast tracking of the criminal justice system. I am for the abolition of the preliminary inquiries, but I'm also against any sort of erosion of the rights of individuals. And I'm thinking, yes, I would support certain parts of this legislation, but the parts that I mentioned, what I'm thinking that would, somehow, we wouldn't have any sort of safety checks in place, and by allowing police officers to now go to any other property, by allowing police officers to have that unlimited times to search a property at different times without having it specified. I'm thinking those two pieces of legislation here, I am very hesitant in giving support of this because I've seen what abuse of that powers could lead to certain individuals ending up with post-traumatic stress and even property damage. Thank you, Madam President.
Mark.
Thank you. Thank you very much. Madam President, I'm very happy to speak and make my contribution to the bill before us, titled The Administration of Justice, Indictable Proceedings, Amendment number 3, Bill 2019. Madam President, may I say from the outset that when we are addressing legislation, particularly of the type that we are addressing, there is need for a sense of balance between criminality and the protection of privacy and people's property, or what I call property rights. Legislation tilted or weighed too heavily in favor of the executive and the prosecution, as well as the police, could represent dangerous business. I recall looking at a Supreme Court decision in the United States, and the definition of search was provided by this Supreme Court judgment. And it says, Madam President, search, and I quote, means a governmental invasion of a person's privacy. That is what a search means. And that is in accordance with the Supreme Court of the United States definition of a search. So, Madam President, the government has brought this bill, and I will show in my contribution that it is riddled with several loopholes for many people to escape. They know who they are. it has a number of deficiencies and shortcomings. And Madam President, if not carefully addressed, it will result in what I describe, or I would like to describe, as a prosecutor's paradise and a defense nightmare. Madam President, we must do everything to ensure that there is balance in whatever we are doing. And you cannot tilt the scales of justice too far in favor of the executive arm of the state and all its agencies. Because that can pose a danger to the democracy and our democratic way of life, values, and norms. Madam President, the bill as currently constructed is dangerously deceptive. And it can result in conflicts, not only as it relates to our Constitution. As I talk about Constitution, let me remind this Honorable House that under Section 2 of our Constitution, 5 subsection 2, that is, Madam President, it says that Parliament may not deprive a person charged with a criminal offense of the right to a fair and public hearing by an independent and impartial tribunal. I will show in my presentation an attempt by the government in this legislation to establish a secret court. So open justice.
You need to rephrase.
No,
what you're
no,
saying
well,
there. Yeah, I think you do. Could you just continue?
No, I'm saying that I will show that there is a provision in the law, which I can quote for you, in which, for instance, the government, through the Attorney General, is saying that a master who is less than a judge doesn't have the power, as far as I'm concerned, of a judge, can determine if your matter should be held in the open. That means a public hearing in accordance with our Constitution. So, Madam President, what conclusion must I draw if you are telling me no public hearing, a judge or a master can determine that? What does that tell me? It tells me, Madam President, that there will be a secret hearing in chamber where the media will be not. Imagine, Madam President, in a democratic country in the 21st century, we are passing legislation or attempting to pass legislation where we are giving a master the power to determine if a hearing will be public and open. And it means that the media would not be allowed in. If I want to be in, I cannot be in. Madam President, that is dangerous, unacceptable, and indefensible. Madam President, I will also show in my contribution that this legislation that we have before us, very, very early, is designed to weaken. It is designed to weaken the system of justice and the fair play and balance that is required in our system. The government led by the Attorney General is attempting to weaken the system that we currently enjoy in this society. Madam President, let me go to clause 3, because I will go to clause 5, but I won't detain you too long on that, because I have many other clauses to deal with. Madam President, would you believe that this government in clause 3 purports to amend the definition of a search warrant to include what they call similar warrants under what they call any other written law, including the subject that is the act. Search warrants are available, as you know, Madam President, under, as far as I am concerned, based on my research, the Proceedings of Crime Act, POCA, the Dangerous Drugs Act, the Firearms Act, the Anti-Gang Act. So, Madam President, what is being said here is that a master, a magistrate, and now a registrar will have the power, Madam President, to issue search warrants, including under the Proceedings of Crime Act and the Dangerous Drugs Act. Madam President, may I remind you that we are not dealing with substantive legislation here today. This is procedural legislation. And what I would like to ask, Madam President, through you, is that the bill that we are dealing with, gives power or powers to masters, as I said, to registrars, and to magistrates to perform various functions. So what is required here, Madam President, is this. Is this bill that we have before you and the amendments that we are proposing, are these amendments in terms of the issuance of warrants, search warrants, are we talking about, Madam President, in this instance, allowing these persons or these office holders, I should say, masters, registrars, and magistrates, to issue search warrants that can only be issued in accordance, Madam President, with Section 33 of POCA, that is the Proceedings of Crime Act, by a judge, and Section 49 of the Dangerous Drugs Act by a judge. Are we now saying that the judges in these two acts will no longer have that power, and that is now a power that is being given to the master of these courts? Madam President, I don't think the government has thought through this thing carefully, because there's a clash, Madam President. Only a judge can issue search warrants under POCA and the Dangerous Drug Act. And therefore, there is no justification offered by the government at this stage as to why a lesser judicial officer should now be allowed to issue search warrants under the Act. And the way, Madam President, we are dealing with, as I said, with procedural provisions rather than substantive law. So I would like the Attorney General, when he's winding up, to clear the air on this matter in Clause 3 when it comes to any other written laws and indeed also with search warrants. I have made my position, as Mr. Bannon would say, pellucidly clear. Madam President, I would like to deal just briefly with the matter of this warrant. I know that a lot of my colleagues would have labored on this point. I would simply like to say that there are constitutional points that must be considered when we are dealing with this search warrant matter. And I want to warn this government that seems to be going on a speedy course, that they better mash brakes, because this bill in its current form violates sections 4 and 5 of our Constitution. And if they do not change certain provisions in this bill, in this parliament today, then they'll be forced to change it at the High Court. We are not prepared to allow the PNM and this Attorney General to undermine the rights and freedoms of the people of the Republic of Trinidad and Tobago. So, Madam President, may I just again, based on what I have done in terms of research, indicate that upon the research conducted, it is clear to me that the government is on a dangerous path as it relates to these measures, as it relates to unlimited, multiple, and all the cosmetic changes that it sought to bring, but does not, at the end of the day, change the price of cocoa. Madam President, I want to advise the Attorney General, through you, that there's a Supreme Court judgment out of the courts of Canada that he may do well to study, because he might need this in the court case that he may have to face if he continues to go along the line that he's pursuing. Madam President, on page 3 of this Supreme Court case dated 1990, the judges, there were 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 Supreme Court judges in this judgment of the Canadian Supreme Court of 1990. And I want to read this part for you, Madam President, very slowly, because I'm not going to labor and bore you with this matter of search warrant, which has been exhausted. I am dealing with principles of law, even though I'm a bush lawyer. Madam President, hear what the Supreme Court of Canada had to say on this matter of searches. It says, and I quote, "The exercise of the power to search is not, however, unlimited." This government wants to give unlimited powers to the police to come into your premises and my premises and the people's premises to search. Multiple searches. Here what it says, Madam President. First, this power does not impose a duty. The police have some discretion, and if satisfied that the law can be effectively and safely applied, they may see fit not to conduct a search. This is a judgment of the Supreme Court. They must also be in a position to assess the circumstances of each case so as to determine whether a search meets the underlying objectives forming the basis of the right to search. Madam President, these are principles that governs searches of people's homes and persons. Second, as regards these objectives, the search must be for a valid objective in pursuit of the ends of criminal justice, such as the discovery of an object that may be a threat to the safety of the police, the accused, or the public, or that may facilitate escape or act as evidence against the accused, and the purpose of the search must not be unrelated to the objectives of the proper administration of justice. What this is saying, your searches must not be politically motivated. That is what it is saying. And third, Madam President, and I'm coming to the end of this quotation, the search must not be conducted in an abusive fashion. Let me repeat. The Supreme Court of Canada, it must not be conducted in an abusive fashion, and in particular, the use of physical or psychological constraint should be proportionate to the objective sought and the other circumstances of the situation. I end, Madam President, with this sentence: a search which does not Madam President, may I repeat? A search which does not meet these objectives could be characterized as unreasonable and unjustified. I will pass this judgment to the Attorney General, because you will need it. Madam President, let me go on to deal with some other pressing matters in this bill. Madam President, may I invite you to join me and look at Clause 8 of this bill. Clause 8 of the bill, Madam President, directly impinges upon the liberty of its citizens and therefore engages sections 4 and 5 of the Constitution. This is what my research has shown, Madam President. The substitution, we have gone, Madam President, from arrest to charge. And you know, this thing might have escaped a lot of my colleagues here, but this is very dangerous business. The substitution of arrest to charge is significant, as it, in effect, Madam President, means that a citizen will be deprived of a judicial process and remedy for a longer period of time. Madam President, when a citizen is arrested, he can be detained for a reasonable period of time to facilitate the investigation. The common law, as it is now requires, that the police justify the detention no matter how long that period, Madam President. If the period is unjustifiable, then a citizen, Madam President, has a right to make an application for habeas corpus. Madam President, this particular clause is seeking essentially to defeat the right to habeas corpus because it allows detention for the purposes of charging someone. So we move from arresting someone to charging someone, Madam President, and therefore the police can simply say that a citizen is being detained because he's about to be charged. And that would enable the police to detain a citizen for a longer period, Madam President. Madam President, if the word arrest is used, then the police must act expeditiously to conclude their investigation from the time the person or the citizen is arrested. So, Madam President, the government, as I said, is moving to delete arrest and go to charge. And there are implications for citizens' rights as it relates to police action and the period of time that people, citizens that is, are going to be detained. And I'm saying, Madam President, it is infringing and undermining the habeas corpus that we are entitled to, and is also clashing with sections 4 and 5 of our Constitution. So I just want to warn this government that is going down a very slippery slope, Madam President. Madam President, I didn't agree with my colleague, Senator Vieira, when he said that preliminary inquiries is irrelevant and archaic and it has outlived its usefulness. I don't support that. And I'll give you some evidence to show how in the last few years in Trinidad and Tobago, particularly in the last 2 years, how preliminary inquiries have been working very, very well in this country under the new chief magistrate. And I'll show further, Madam President, the bottleneck is really in the office of the DPP and the High Court. That is where the bottleneck is. Madam President, you know what I found very interesting? Clause 11. Madam President, I found clause 11 to be interesting. This clause seeks to amend section 11 of the Act. And this, as you recall, Madam President, the Attorney General, in seeking to speed up preliminary inquiries through, well, abandoning preliminary inquiry through initial and sufficiency hearings, came to this Parliament, and we all agree that this thing should be time-bound. So there were time frames established for everything, Madam President, including witness statements. Madam President, you know what the Attorney General has done? He has somersaulted, capsized. Every time frame that the AG established some months ago, Madam President, he has now removed. So what is this AG about? He's speaking from both sides, Madam President, of his mouth. And you don't know what to believe.
No, well, Senator
All
Moore.
right, I withdraw.
Yes, thank you
And
very
I
much.
apologize to you. Yes, well, he has my apologies full and blast. A full blast. He's my friend, you know. Well, I too. No love lost. Madam President, may I continue? No, I have a long way to go, darling. You're not going to interrupt me today. Oh, sorry, ma'am. Sorry. That's my friend. That's my friend. But sorry, I withdraw that word. I withdraw that word, ma'am.
No, darling, for you.
Yeah. Madam President, I seek your protection. Eh? You know, Madam President, this is Christmas, eh? So it's only love. It's love. You know that, right? Love is in the house. Madam President, may I go to clause 11 with your leave? Madam President, when I looked at clause 11, it seeks to amend clause 11 amends section 11 of the Act. And that is dealing with deadlines, Madam President, and time frames for compliance with various requirements and directions pursuant to a sufficiency hearing. Now, Madam President, the current law sets out the following timelines. I must give you an appreciation of the current reality. That is what we have now. And I will then tell you what is being proposed in this section 11 or clause 11. Madam President, in Roman 3, section 11, section 11 rather of the law, it says that the prosecutor shall file in the High Court and serve on the accused all witness statements and other documentary evidence that he intends to use at the sufficiency hearing, which date shall be no later than 3 months from the making of the scheduling order. So, Madam President, there is a time frame in the current legislation for this matter of serving witness statements and other documentary evidence that he intends to use at the sufficiency hearing. Madam President, in Roman 4, it goes on. That's a time-bound arrangement. The accused shall file in the High Court and serve on the prosecutor any witness statement and other documentary evidence that he intends to use at the sufficiency hearing, which date shall be no later than 28 days from the date on which the witness statements and other documentary evidence are served. So, Madam President, one is 3 months. And, Madam President, you see the unfairness? The prosecution has 3 months, but the accused is given 28 days. This is a prosecutor paradise and a defense nightmare. There is no equity, there is no balance, there is no justice in the provisions that we have before us. Madam President, the last one says, the sufficiency hearing shall commence, which date shall be no later than 28 days from the date on which witness statements and other documentary evidence are served. Madam President, would you believe, that in our current legislation that we are debating, the Attorney General is saying in the legislation, or the legislation is proposing, I should say, where the prosecutor, the accused, or the legal aid and advisory authority applies for an extension under subsection 2. So they say that they are now changing, Madam President, where they're saying that you could now apply for an extension. The master may grant no more than one extension, not exceeding 40 days to the applicant. That is what you can get at the moment if you apply for an extension. Madam President, given these sufficiency hearings are supposed to speed up the system, the current proposed amendments, Madam President, would gravely slow it down, opening the doors for multiple adjournments and delays. So what the government is seeking to do, Madam President, is give the master the power to extend the period of time for all these matters. So rather than have time-bound periods, it is now going to be left up to the master to determine, Madam President, if they will grant you an extension and how long it will take. It may take 10 months, it may take 11 months, I do not know, 10 years, I don't know, Madam President. No, Madam President, whilst our Constitution does not provide a right to a quick or speedy trial, in other jurisdictions, including the UK and Canada, the court will dismiss prosecutions for non-compliance with timetables, Madam President. So there is no reason why our prosecutors should not be held to the same standards. So, Madam President, this is something that I am trying to get clarified as it relates to the Attorney General, because we have a situation, Madam President, where the government has brought amendments, and sometimes I wonder, Madam President, and the Attorney General needs to answer, is this ad hominem legislation? Is this legislation designed to achieve a particular objective, Madam President? I would like to ask the Attorney General in this Parliament today whether he has to appear as a witness in a witness tampering matter. His statement is yet to be signed, and the matter is headed for the courts to be heard on at some time on January 20th, 2020. Is the Attorney General directly involved in a matter?
Senator Mark, I will not allow you to proceed along this path. I would ask you please to desist and to continue with your presentation.
Madam President, as you know, I always take your guidance, especially around Christmas time. Madam President, may I continue? I'll ask him on the public platform. Yeah, you'll answer. You have a lot to answer. No. So sorry, Madam President. Sorry. I withdraw. Madam President, the unfettered discretion of the master to extend deadlines for submission of statements and or material for sufficiency hearing is contrary to the intent and purpose of the proposed legislation. The entire point of abolishing preliminary inquiries is to expedite the criminal process and to ensure that matters that come before a high court judge within it that comes before a high court judge within a reasonable time, Madam President. If there are no timelines for these documents to be furnished to the master, then the entire purpose of this legislation is being frustrated. You understand? There's no timeline. A master should not, Madam President, I want to repeat, a master should not have absolute discretion to extend time. The legislation should ensure very strict timelines for the prosecution to submit its evidence, which it intends to rely in order to secure promptitude from prosecuting authorities. There should be no time, there should be a strict time frame, Madam President. Madam President, it is said that absolute discretion is the antithesis of legality. A discretion ought not to be drafted so wide and vague, particularly in the criminal context, and that could allow a master to extend time for any reason. So this master, Madam President, can extend time for any reason. A master is not the law, you know. The law must guide the master. The master is not the law. So, Madam President, the legislation should at least say time is only to be extended for good and proper reason. Attorney General, I would like you to consider amendments to the legislation on this particular matter. You should only have an extension of time, Madam President, for good and proper reason. And further, if more time is required, sworn evidence should be required. If more time is needed, sworn evidence should be required. Madam President, too often in the criminal courts, police come to court and ask for adjournments because the complainant is on duty or is on sick leave or the witness had a difficulty. There is no strict requirement to provide documentation to substantiate these excuses, Madam President. Madam President, I think we should borrow from the civil jurisdiction. If a party in civil proceedings needs an extension of time for a witness statement, he usually has to file an application supported by an affidavit. If you miss the deadline, then you must file a relief from sanctions application. It would be prudent to ensure that if the prosecution is going to delay criminal proceedings by not complying with orders, then the prosecution should make an application and demonstrate a good and proper reason supported by evidence. There should also be a limit in the number of times you can ask for an extension of time. And further, the amount of time to be granted, perhaps, Madam President, 1 month and no more. The removal of timelines is a retrograde step and will only propagate a culture of lethargy in the criminal courts. Vagueness in criminal law, Madam President, is unacceptable. And it is our view that no sensible distinction could be made between a criminal offense and a criminal procedure when it comes, Madam President, to ensuring that there is no uncertainty. In fact, there's a law to support the proposition.
Senator Mark, you have 5 more minutes.
Yeah, there's a law to support the proposition that a measure to have the quality of law should be certain, Madam President. So this conferring of discretion so broad on a master, Madam President, to extend time is not acceptable. We will create a judicial system of people. We must create a judicial system of people and not laws. Such a measure does not have the quality of law and therefore could be challenged as being unconstitutionally vague. Madam President, I just want to say that this matter of the PI system, since about for the last 2 years, it has been working extremely well. My research has shown that the matter of preliminary inquiries before the magistracy at this time, Madam President, is working well. The delay, I understand, is at the level of the DPP office and the courts, the high courts of Trinidad and Tobago. That is what I have been able to research. Madam President, the government needs to pour more resources into the office of the DPP and the High Court, because there's where the bottleneck is located. So I don't think preliminary inquiry at the moment as we speak is a problem. I would like to say preliminary inquiries is a safeguard. And you know something, Madam President, this bill that we have now is devoid of any safeguards for the accused and ordinary people. Madam President, I've been advised, based on research too, that over the last 2 years, over 20 persons were discharged at preliminary inquiries before the Chief Magistrate, following cross-examination and legal submission, and those cases did not last as much as a year before this Chief Magistrate. Madam President, if these persons did not have a preliminary inquiry with the opportunity to cross-examine and test evidence, and thereafter make legal submissions, they would have continued to sit in jail on murder charges for many more years until the DPP decides to file his indictment and a court is available to try them. Madam President, I want to say in closing, I have 3 more minutes, I think. I have 2 more minutes? 1 more minute. We always hear about the government meeting with the Chief Justice and the judiciary. I want to refer the Attorney General to this book by Lord Bingham, The Rule of Law. And I want him to go to page 93 and 94 and see what the Lord Chief Justice, former Lord Chief Justice, had to say about this cozy relationship between the judiciary and the administration at the executive level. Madam President, with these few words, I want to thank you very much for allowing me to make my contribution this evening. Thank you.
Before I call on the Attorney General, may I just indicate that the tea is available. Members can avail themselves of it. We will not formally be breaking at this stage. Attorney General.
Thank you, Madam President. Madam President, I wish to thank all honourable senators for their contributions. Madam President, the Office of the Attorney General is one that is required to work all the time. And I confess that whilst I'm sitting here in this house, many of you would have seen boxes and boxes of papers that come at me and go back. The office continues to function. And in receiving the boxes this afternoon and going through correspondence, Madam President, I received a letter. It's stamped the 18th of December 2019. It comes from one Russell Gonzalez. It's funny the way the Almighty works. This letter addressed to me refers to a letter sent to me in April 2016 concerning prison reform consultation at Remand Yard. And the letter encloses an article written by the new Archbishop in the latest edition of Catholic News. And attached to that is a publication coming from the Catholic News, Sunday, December 8th, 2019. It is Conversations with Archbishop J. It's entitled Behind Prison Walls, Advent Lives. Question, Archbishop J, what is your Advent highlight? And it begins this way, and if you'd permit me just to quote briefly from this. Advent is about waiting in joyful hope. Visiting the prison during this time has opened the season's mystery in a new and exciting way. Waiting has a very different meaning for the men and women in prison. I understand why Jesus highlights the prisoner as a special way of encountering his love. Matthew 25:36. The prisoner in Trinidad lives in a perpetual state of Advent. They are constantly waiting in brutal and inhumane circumstances. In them, God is waiting. And this article then goes on through many paragraphs, in particular to reflect upon remand conditions, where persons have access bail but cannot take advantage of the access to bail. The article notes that there have been significant amendments, for instance, the bail, access to bail legislation that we passed, which is in fact working, etc. And it quotes this, and I'll just end with this last quote. One young man made me promise I would speak of the injustice in the system. one young woman made me promise I would not forget her or her case. They would not let me go till I promised. Someone had to listen and respond, to care and believe. I couldn't imagine getting this letter and this publication at a more appropriate time than today while I sat here in this chamber. You see, Madam Speaker, Madam President, my colleagues opposite stand, sometimes with excellent submissions, but most often clothed in the threat of going to court, of a lack of support, of a need for more reform. Senator Hussain asked today, why the rush? Why the rush? 26 years of talking in this country about abolishing preliminary inquiries. In that 26-year period, let me put it on record, the UNC had control of government in that 26-year period for 10 years and 3 months. And in the last 4 years of this government, this parliament can safely testify to a system for the administration of justice that has been implemented in a way that no other government has brought it to life. Senator Hussain was quite strident in making the observation, his observation, that not a single court was opened. To the Honourable Senator, I'll be charitable this afternoon in my reply. To the Honourable Senator, there have been 22 courtrooms created between the Children's Court and the Family Court structures alone. 22 courtrooms, Madam President. In the Hall of Justice, we'll get 70 courtrooms this year. And why the rush? Through you, Madam President, in answer to Senator Hussain, because this parliament is going to close this week. This parliament is going to move from this building into the Red House, and this parliament will not be able to sit until the end of January. So why the rush? I make no apology that in this season of Advent, that where Advent exists as the Archbishop has put behind the walls of the prison, one day more in facilitating and promoting delay is one day of hell to someone. And if Senator Hussain is inconvenienced by having to sit in this parliament, which pays each and every one of us to be here, to do the job, well then so be it for Senator Hussain. I can't drag him to the water and force him to intellectually drink from that fountain, Madam President. But I'm prepared to be here. I'm prepared to be here. Why the rush? Senator Hussain recommended as a submission for us, Madam President. Madam President, let's deal with a few of these strong positions coming forward. We heard Senator Mark and Senator Hussain and Senator Sobers, quite surprisingly. He built the courage to make the submission, almost timidly as if he didn't believe in it himself, making the allegation that this law is unconstitutional, Madam President. Senator Mark described himself, I don't like the term, but Senator Mark described himself as a Bush lawyer. And I'd like to stress the word Bush in that position. Senator Mark, in special, well, not marijuana yet. Madam President, Senator Mark made the submission, the most incredible submission. Senator Mark made the submission that this law was so grossly unconstitutional, and then he went further to say that we were infringing habeas corpus by the law. And Senator Mark reminded us of the written constitution, and Senator Hussain quoted from the written constitution. Madam President, let me remind you, this law is statutory law. This law has been brought with a simple majority. Why? Number one, we have a legitimate aim. The legitimate aim is to reform the system of pretrial scrutiny and to abolish preliminary inquiries, not to modify a system of professional inquiries, preliminary inquiries, Senator Hussain. It is to abolish preliminary inquiries. Let me make that clear. Secondly, that legitimate aim is tied into the system as we know it. Delayed justice, thousands of cases in a state of disarray, hundreds of thousands of people and man hours having been poured into a system that just doesn't work. It is an ossified system as per Lord Devlin. Thanks to Senator Deyalsingh for reminding us of that quotation way back in 1960. That legitimate aim has been upheld by the Privy Council in the Hilroy Humphreys case. That legitimate aim is being treated by a law which we amend today, and I make no apology for amending the law for a third time. That's what the Parliament is here for. Having received consultation with a view to proclaiming this law, in particular from the judiciary and also from the Director of Public Prosecutions and Senior Counsel to the Director, there is no cozy relationship. We're bound to make that consultative approach in the process of proclaiming law. Senator Mark ought to know that. In a different incarnation, he sat in the House of Representatives in a different place. And he saw the reading out of a letter from Roger Gaspard, QS, SC, written to Anand Ramlogan, Attorney General, saying, you failed to consult with me when you proclaimed Section 34. And we convened the House on a Saturday to remove Section 34 from the laws of Trinidad and Tobago. That was met with the consultation from the judiciary then. So why pour scorn and allege that it is a chummy and unholy relationship? We are bound in the operationalization of law before we proclaim to consult with these personalities, but we do so with propriety. The Third Amendment, rationally connected in the laws that we bring to a legitimate aim, is that we prescribe a system that is now tighter in how we process flow the matters. Do we go any further than we ought to? That's the third limb of proportionality, which is the test of constitutionality, set out in the Northern Construction case, set out in Baroness Hale's contemplations in the Surratt case, set out in so many cases, too numerous to mention. No, we don't. And in the round, we are allowed to treat with Section 4 and 5 rights in the manner that we do, because we are clothed with due process. And that's what I meant by Senator Hussain reading the Constitution. I noted his voice dropped when he saw the words. But like a skillful young advocate, as he is, Senator Hussain sought to just quickly step by it. So I'll put the stress in the way that I wish to put it, in the manner to the opposite of Senator Hussain. He's a young, fighting young man. I make no criticism of my learned friend, Senator Hussain. But let me read it the way I think it ought to be read. Rights enshrined, Part 1, Section 4. The right of the individual to life, liberty, security of the person, and enjoyment of property, and the right not to be deprived thereof, except by due process of law. Stress. What does that mean? By court process, by the separation of the powers, by the separation of the three articles upon which we maneuver our society, the judiciary, the legislature, and the cabinet. And therefore, due process, recognized by Baroness Hale, recognized in Northern Construction case, due process tells us once your court is going to decide the process, you're in a safe zone. And that's what we do. That's why Hilroy Humphreys in the Privy Council was upheld as not infringing the law. But let me get to the remarkable submission by Senator Mark, who then, after making the submission that we were unconstitutional, went on to make this wild allegation, as a self-professed Bush lawyer, that we were infringing and whittling away against habeas corpus. For heaven's sake, Madam President. Section 5 of the Constitution says, except as is otherwise expressly provided in this chapter and in Section 54, no law may abrogate, abridge, or infringe, or authorize the abrogation, abridgment, or infringement of any of the rights and freedoms hereinbefore recognized and declared. Without prejudice to subsection 1, but subject to this chapter and to Section 54, Parliament may not C. Deprive a person who has been arrested or detained, and let's jump right down, to the remedy by way of habeas corpus, this is Roman 4, for the determination of the validity of his detention and for his release if the detention is not lawful. Now, Madam President, the supreme law is the supreme law. Section 2 of the Constitution says the Constitution is the supreme law. Section 5 says you can't abrogate from the law unless there's an exception in the Constitution by Section 13 or Section 54. Madam President, how could we in statutory law be abrogating the right, which is a constitutional right of habeas corpus? It just does not add up. And therefore, I humbly suggest in the next 5 years that the Honourable Senator will have ahead of him, 6 years, my good friend Senator Mark, that whilst he is in the wilderness of opposition, he should use the opportunity to qualify as an attorney at law and move himself out of the realm of bush lawyering into actual lawyering and read the Constitution. My dear friend Senator Mark, who I have great love for, Madam President. Madam President, I'm going, with your leave, to mention something now. Sometimes we have to do the right thing because it's the right thing to do. Take support for cybercrime legislation. Madam President, I want to openly condemn here in Trinidad and Tobago what I consider to be an act of misogyny and an act of a brutal act upon a citizen of this country. There is a young woman who has risen to the rank of mayor in this country. And I wish to condemn the attacks that are being put out against her right now and to say that Trinidad and Tobago needs to grow up. We need to grow up and we need to respect people. None of us are perfect. None of us know the circumstances that someone may have found themselves in. And we ought to cease and desist immediately from attacking someone in this society. And I say so even if that person is somebody who is in a political party opposite to me, Madam President. We have to do the right thing, Madam President. And I would like, as a Senate, on behalf of all of us here, I'm sure I speak for all of us, to put that recommendation to our public. Madam President, let's jump back to the submissions before us. I've addressed the constitutionality. Let's get into the position of...
Continue, AG.
Thank you, Madam President. Let's get into the position of other substance, Madam President. Madam President, we had a few questions asked directly in respect of the bill. First of all, I want to give an undertaking to my learned friend, my Senator Hazel Thompson-Ahye. I have given the undertaking before, and I will discharge that undertaking, looking at the age of discretion, looking at the age of prosecution in this country. I have taken avail of the circumstances. We're in the act of consultation right now, and I certainly intend to be making the recommendations that I must. On the second ground of the need for prison reform, and in particular a system of parole, I have drafted the law already. I intend to bring that law to the Cabinet immediately and to seek the introduction of that law into this Parliament. I have drafted the law already. The same way I have drafted campaign finance law, the same way I have drafted other amendments to significant laws, domestic abuse, sexual harassment, arbitration. There are some significant laws in the work ahead of us. And honorable senators, I again come back to the point, I'm not rushing the law. We just can't wait until the end of January for this law to go live. Hence the indulgence upon the time of the Senate. Madam President, I can tell you that with respect to the system of search warrants and the recommendations coming from learned senior counsel Senator Choate, I do agree that there's a time that we ought to have the prescriptive aspects of what goes before the judicial officer in the grant of the warrant. Senator Choate has made that recommendation on a previous occasion. Certainly, I think more than one occasion we have received that. I think it's a very excellent and commendable position. I'm not yet in a position to make the recommendations to that effect. The stakeholders have asked us simply to carry the law of search warrants as it exists in Section 5 of the Act, that is the current law, Chapter 1201, the Preliminary Inquiries Act, into the form and fashion. We are seeking to codify today into statute the concept of multiple search warrants. Senator Choate has already, for the record, recognized that multiple search warrants can, in fact, and are done by way of technique. Multiple officers asking for different premises. The common law allows you the right of hot pursuit. you can get into the situation of entering premises. We prefer not to do that. We prefer to give the novelty on this occasion to the master, to allow the master, and not a magistrate. We're going up from judicial consideration from a magistrate, which is the existing law, to a master. We're asking for a master to consider the circumstances for the grant of a warrant for multiple searches. And for the first time, we are including time prescriptions because the master may include terms and conditions into the warrant. Our law does not provide in Chapter 1201 for prescriptive limits. There's a rule of thumb that they use the validity of the warrant for 1 month and then they go back for a fresh warrant. The only law where I've seen the need for a continuation of warrant system is under the Interception of Communication Act in sections 8 and 11 of the Interception of Communications Act, where you want to go beyond the 90-day period for having someone on warranted interception. Madam President, Senator Choate also made the recommendation that we have the persons named as persons who are assisting. I looked at that by way of recommendation. I contacted the various stakeholders who kindly responded with immediacy. And what I can tell you, Madam President, is that we modeled after PACE, number one. Number two, the position was that the certainty of the technical officers is often not known until the very last moment because it shifts in terms of circumstances. The rationale for this is largely on the IT platform or forensics expert platform. On the IT platform, it is critical to make sure that no damage is done to computers, etc. But I want to also rely upon the rules of discovery, the rules of disclosure, and the criminal proceedings rules. In the collection of those rules, you must disclose your case to the personalities, the accused, and to counsel for the accused. You must disclose that to the court. You must disclose the case that is prejudicial to yourself, as a matter of fact. And therefore, the identity of the person who accompanies the officer named in the warrant will always be discovered and disclosed. And I think respectfully that we can let that system work its way out the way the PACE English law had its system work out. Madam President, I looked at Senator Choate's recommendation, and I thank her for giving way to clarify that we ought to have the defense time for filing of statements moved up from 28 days. I noticed that the newspapers have already put out online the submission, which is not what Senator Choate said. The newspapers put out that we were somehow going to only have 28 days for the defense, and that somehow we were giving just the prosecution and the DPP and the court the ability to extend the time. Madam President, as a matter of fact, the 28 days is now circumscribed for the first time by saying you'll have 28 days, but the master may, at the request of the defense as well, extend the time frame. So we've put the 28 days. The time frame applies. Senator Mark made the submission that you ought not to allow this thing to go on indefinitely. He made a most spectacular submission that a master ought not to have the liberty to decide the extensions of time. That is, in fact, something that skirts along the line of interference with the judicial discretion at law, the separation of powers principle, and we have to be very careful about infringing the constitutional arrangements there. We believe that allowing for the extension of time in the interest of justice specifically preserves the right of the defense attorney, the right of the accused, to ask for discharge on the ground of delay. Nothing changes that. We've statutorily provided for it in Section 24 of the Parent Act, where the discharge can be done for other than scheduled Section 6 offenses if the DPP fails to act within 1 year, but there's nothing to stop the court receiving submissions that the matter ought to be discharged on the ground of delay. We had decided upon the 28 days. We use that formula right throughout, but I want to specifically underline that we're leaving it to the discretion of the court. Obviously, the criminal proceedings rules, just like the civil proceedings rules, will kick into effect. Obviously, the judiciary still has preserved onto it something called an unless order. Unless orders are done at the invocation of defense attorneys in the civil arena by the court and also by both sides, claimant and defense, and the court makes an order. Unless you do something, there will be a consequence. So the unless order provision obviously applies, and the rules of the Supreme Court pursuant to the Supreme Court of Judicature Act can be amended from time to time. Senator Vieira, I think, made the point that we would love to see the embodiment of the practice direction of the Chief Justice. And I would just like to tell you, I do agree. Fortunately, however, the court had the ability to pronounce upon this position. It's a settled case right now. Garth O'Brien and the Honorable Chief Justice Ivor Archie. Take a guess who went to court to say that the criminal proceedings rules were unconstitutional. The UNC. Wayne Sturge, sitting senator, went to court, CV 2018-00854, known advocate for the UNC, went to court to challenge the issuance of the criminal proceedings rules, asking for an order of certiorari, a declaration that directions contained in the practice direction are ultra vires, unconstitutional, illegal, null, void, and of no effect. Fortunately, common sense, prudence, and good law was upheld, and the court very happily rejected the submissions coming from the UNC advocates and upheld the constitutionality. Madam Justice Joan Charles did that. The sanctity, therefore, of the flexible approach of practice directions and the rules of the Supreme Court have therefore been upheld by the courts, and I think that we can allow that to continue to prosper as we work out the bugs in the application of this law. Section 14B, Senator Choate invited a reflection upon that. I think it was very prudent to ask for that. I regret that I didn't in the piloting have the time that I required to do the reflections on that, so permit me to do that now. Madam President, we are in clause 24, seeking to abolish the application of section 14B of the Evidence Act. Section 14B of the Evidence Act is in equal terms to section 69 of the PACE Act. Section 69 of the PACE Act was in fact abolished, repealed by amendments coming in the year 2000 when they had an abolition of that. Section 14 of our law is actually something which works against us. Let me give you some of the reflection of section 14B. Section 14B says, in any criminal proceedings, a statement contained in a document produced by a computer shall be admissible as evidence of any fact stated therein if it is shown that A, there are no reasonable grounds for believing that the statement is inaccurate because of improper use of the computer. B, at all material times the computer was operating properly, or if not, that any respect in which it was not operating properly or was out of operation was not such as to affect the production of the document or the accuracy of its contents. And Madam President, the problem in this, as it manifested itself in England, as they began to go deeper and deeper into their financial crimes and complex fraud matters in particular, computer-oriented positions, and as Senator Vieira quite correctly put, we're in the fourth industrial revolution. Our children of the generation now in their 20s and upward, they are native to the digital age. Let me repeat that. They are native to the digital age. They don't have to think by way of algorithms. They look and feel. They know that double tapping does something, or flipping does something, or a gesture does something. You can actually look at little babies right now with iPads in their hands, and they can maneuver successfully by look and feel, as opposed to arithmetic or logical approach that we sequentially apply from an analog era. It's a very different regime, proving that at all material times a computer was operating properly is a very difficult thing. And it's almost an impossibility. And I'd like to take us to the International Conference on Electronic Litigation, Editor-in-Chief Justice Lee Siew Kin, General Editor Yong Zi Kin. It's a publication reflecting upon the amendments, which are exact amendments to what we're doing now in Singapore. And in Singapore, they had a very interesting position. They reflected upon the English position and the Singapore position. The Singapore position is Section 35 of their law. And they said, and they're quoting now with respect to the English comparator, what is the equivalent of our Section 14b? Fails to address the major cause of inaccuracy in computer evidence, that is human error. Advances in technology make it impossible to comply with Section 69 of PACE, as it is increasingly impracticable to certify the proper workings of all of the intricacies of the computer operation. Recipient of computer-produced document who wishes to tender it into evidence may well be in no position to satisfy the court about the operation of the computer. It is illogical that Section 69 of PACE applies where the document is tendered in evidence, but not where it is used by an expert at arriving at his or her conclusion, nor where a witness uses it to refresh his or her memory. If it is safe to admit evidence which relies on and incorporates the output from the computer, it is hard to see why that output should not itself be admissible. The Law Commission had reasoned that the major cause of inaccuracy in electronic device evidence is human error, not the reliability of the computer itself. Insofar as the reliability of the computer operation is concerned, it was sufficient that the common law maxim of presumuntur omnia rete esse acta would apply. That's well known to us. There's a presumption at law that there is regularity in regularity, or that it's safe if it's good, put quite simply. So we have an origin. Our Section 14b of the Evidence Act is quite simply just archaic. It is technologically specific as opposed to neutral. Other jurisdictions got rid of it nearly 20 years ago, and we are in the domain of follow the money, of explain your wealth, contrary to Senator Haynes's bold assertion today that this government has not operationalized any of its laws. Let me remind honorable senators today. We were told by the opposition, nobody in their right mind would use judge only, especially for murder. We have had judge only trials for murder, and in fact we're on the second trial right now. In the first matter, Justice Lucky, in fact, acquitted for murder. We have had judge-only trials for money laundering. We've had judge-only trials interposition. We've had plea bargaining when we passed the plea bargaining legislation that we brought as a Senate altogether. We have had ease in the access to bail as a result of the laws that we have brought. And very particularly, without going into any of the details of it, we have made history as a country in having the first two preliminary unexplained wealth orders ordered by the court last week, Monday. Let me repeat that. We have made history as a country in having the first two preliminary unexplained wealth orders done. Why? In England, unexplained wealth orders are only done for politically exposed people. That is tied into everything that we do. All of the systems and processes as we amend the laws to treat with land, companies, beneficial ownership, registration of deeds, as you'll see in the month of January, demonetization of money. All of these pieces come together because we say time and time again, and in another place, I am regaled with the virtues of the laws of Singapore over and over and over again. But in Singapore, Madam President, if you spit on the sidewalk with chewing gum, you are publicly flogged on television. If you are caught trafficking in firearms, in certain circumstances, you meet the hangman in Singapore. So we want all of Singapore, but we want none of the discipline to get there, Madam President. And that's where the UNC and the PNM depart ways. So while Senator Mark has boldly threatened to go to court, to go and meet us in a constitutional court on this law, I welcome that. It will not be met with any form of favor, just like the attempts to go to court And just like the beating the UNC attorneys got on 4 occasions to deal with the property tax enforcement, they will be met with a defeat in court. Because, Madam President, from the Privy Council come down, we have had assertions of propriety in relation to this law. So, Madam President, that addresses, I hope, in proper form, the rationale for the abolition of Section 14B procedures, the repealing of that law. It's true that we had looked at it at the Special Select Committee in the public hearings to treat with the evidence bill. The DPP spoke to it specifically when interrogated and asked questions in the course of that public hearing, which was on television. And, of course, in the course of consultation of this bill, the DPP also echoed support for the repeal of this particular provision, Madam President. Madam President, we heard mention of the courts and the DPP's office, etc. Let me report now. Senator Haynes was reflecting upon a 2016 report to the Joint Select Committee, Madam President. I can tell you right now, we have opened the DPP's office in Tobago already. All of the ranks in the legal officer, legal counsel, 1 position have been filled. In case you didn't notice, we have carved out the fees for the DPP from the Attorney General's office. There's a separate line item for the DPP. The Port of Spain offices at Park Street for the DPP are being outfitted as we speak right now by UDCOT. And those offices will be opened in the early part of next year. The Public Defenders Division, which picks up upon Senator Choate's correct acknowledgement that the criminal bar is extremely small. There are about 20 of the high-powered lawyers that control the criminal bar, just 20. So even though we have raised judicial complement by 76%, even though we will birth 100 criminal arena courts, even though we have rules of court, even though we have processes, even though we have IT, if you don't have a defense attorney, what are you going to do? We have brought that by way of a practical reformation of the Legal Aid and Advice Authority. We have birthed the Public Defenders Division. We are adding 30 lawyers in the month of January. We are getting mentors from the Commonwealth to oversee and manage the transfer of information and position. And, Madam President, if your defense counsel is not ready for you, 1 shot, 2 shot, 3 shot, public defender comes to represent you because you have a right to fair trial. You don't have to have counsel of choice. You need competent counsel. So we are not relying upon the law. People, processes, plant and machinery. And I can't stop repeating that formula as much as I can. I must say it because we have to really acknowledge what is being done. But, Madam President, don't take it from me. I want to rebut everything that Senator Hussain and Senator Haynes had to say about operationalization. I invite every member of this country, every citizen of this country, visitor, resident, expert living here, to read the judiciary's publication, its annual report 2018 to 2019. It's entitled Transformation for Enhanced Delivery. And in that, Madam President, you will see page after page, transformation for greater efficiency and public convenience, TT Jim Core, the IT processes, the FTR, the recording systems, the voice-to-text facilities that we use, built on Dragon dictation. You can dictate into your phone via an iPhone Siri app or any other phone. We have taken that, we have trained batches of 50 people instead of taking 3 years to train cat reporters, as we have in the Parliament, at $2 million. We in fact train 50 people for a couple $100,000 and push them out in 3 months. And they're flooding the system. They can work remotely. They can have the access to technology. We have beta and alpha tested the platform for the IT at the judiciary. We have done demonstrations to the bar. We have done demonstrations to the public. The judiciary has managed that. Transformation of traffic courts with TT Jim. We go live on the 22nd of January 2020. E-services, court pay, small claims, courthouse development beginning at page 43. We then go into Magistrates Court building, Princestown, Arima, San Fernando, Sangre Grande, Siparia. I'd like to say that whilst the UNC actually shut down the entire court facilities system in the judiciary, because they said they would build a judicial complex, and I want to remind you, they said that they would build a judicial complex and they effectively shut down the entire court facility management. They didn't build a single judicial facility. They procured a contract which breached the Central Tenders Board and it had to be pulled out. But Madam President, I can tell you, and I say this as the Member of Parliament for San Fernando West, the request for proposals for the Magistrates Court in San Fernando were issued out on Friday. The financing arrangements were put in place by the Cabinet's approval. The Attorney General of Trinidad and Tobago took a property which we own in San Fernando at Irving Street, just by Irving Park, at Sutton Street, at that corner there. We gave it to the judiciary, and they will start construction in the month of January. We were in the course of refurbishing the Magistrates Court at San Fernando, existing court, when the earthquake came and the building had to be condemned. An act of God interrupted that position, but it's a far cry away from the building brought by Anand Ram Logan in San Fernando, which was condemned by the Ministry of Works as being incapable of holding a courthouse. What can I do? It's my job, it's the government's job to operationalize systems, Madam President, and so we must. Even if we have inherited a bad position, it's our job to do it. Madam President, so the judiciary report speaks and certifies all of the transformational measures that are in actual existence. Read it for yourself. Don't take it from me. Understand that
Attorney General, you have 5 more minutes.
Much obliged, ma'am. Understand that in adversarial politics, this is just the way it goes. Madam President, there comes a time when, as a society, we have to accept that enough is enough. Comes a time when you have to draw the line and say, look, I'm prepared to start. We have on umpteen occasions, pursuant to observations with the rollout of law and undertakings at the Parliament, and you have seen that we have kept all of our undertakings. We've come back to the Parliament, we've amended laws, we've taken a very practical approach to the administration of justice. Will we get this perfectly right? I'm sure that there'll be a need for further amendments as we roll it out. Look at what we did in the Family and Children Division. Look at what we did in the package of children's laws. We amended in the first round 19 laws in 2016. Second round 23 laws. We did the rules to govern child rehabilitation centers. We did the orders. We did the designations. We were not ashamed to come back to Parliament, amend, fix, implement. What I can tell you is the courts are up and running. Children are being treated in a way that they never have before. The computerization of all of the magistrates' courts is a feature of today in Trinidad and Tobago. These things didn't happen by mistake, Madam President. We have a very aggressive agenda. Today's opportunity in the Senate to consider this bill is a golden one. The time has come. The House has already adjourned its purpose. I look forward to the committee stage. The Parliament will close. We will at best reopen in the 3rd week of January 2020 at the Red House location. We can't wait between now and then to operationalize this law. The methodology for operationalization comes from the judiciary and the other stakeholders to make sure that we can get this right. Last point. There must be a system of dealing with the backlog. That system involves plea bargaining and maximum sentence indication. The shorter the time frame for a trial, the greater the risk that you will face justice in a faster space of time, the more incentive there is to deal with plea bargaining. It's just simple. If your trial is going to wait 20 years, witness die, judge retire, policeman gone away, well, you're sure you could just run the clock. But as you shorten that gap, which the abolition of preliminary inquiries will do, you will remove decades of delay. You're going to have your backlog being dealt with. and, Madam President, we treat with backlog public defenders, increase in judiciary, increase in technology, increase in DPP, greater funding, we are applying the formula plant and machinery, people, processes, and law. This is constitutional law. I respectfully believe that we've answered the questions posed in the course of debate. I look forward to the committee stage, Madam President, and I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. Those in favour say aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011.
Attorney General.
Madam President, in accordance with Standing Order 66-1, I beg to move that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honourable Senators, the question is that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favour say aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause.
Clauses 1 to 4.
The question is that clauses 1 to 4 stand part of the bill. The question is that clauses 1 to 4 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 4 now stand part of the bill.
Clause 5.
The question is that clause 5 stand part of the bill.
Madam Chair,
Senator Mark.
I want to apologize. I was supposed to circulate an amendment deleting of clause 5. We're not in support of clause 5. But we didn't get a chance, so I'm just putting it down that we're not in favor of clause 5.
Any other questions or comments? Honourable Senators, the question is that clause 5. So when I say any other questions or comments?
Sorry.
Okay.
I do apologize.
Yeah.
Honourable Attorney General, with respect to new clause 2A that deals with the obligations of the constable who is executing the arrest warrant, it's just a matter of clarification. The effect is that if the police officer fails to do any one of the three obligations, I don't know if you're with me. If the police officer, the constable, sorry, fails to identify himself, produce a warrant, or supply a copy of the warrant, what will be the effect of the search, AG?
Sure. Senator Sobers actually answered that in his own contribution. Your own colleague reminded you that the effect of the search would be that that which is committing an offense is still valid under law. If your question relates to what is the consequence to the policeman for failing to do those things, well, then it can deal with a number of things, including breach of regulations, breach of the law, the commission's service positions, the civil side remedies that are available. So I think between Senator Sobers and I, we can confirm that.
It wouldn't go towards deeming the search.
No, our law is clear on that.
Senator Sobers?
Madam Chair, I do apologize. We're on clause 5, correct?
We are.
Right. In terms of clause 5, where it was indicated that we are saying now that the may at any time issue a warrant under his hand.
You can tell us what page?
That would be on
clause
page
5
6. Page 6, please, Madam Chair. I apologize. The inclusion of any person accompanying him. I know that both myself, Senator Hussain, Senator Chote indicated that maybe it would have been better that we could amend that to indicate exactly who that person would have been accompanying the police officer. I don't know if you all considered such an amendment.
So as I indicated in my wrap-up, I did speak to the respective stakeholders across the plate, and the answer to that is, number one, we took the precedent out of pace. Number two, the indication was that there needs to be care as to the availability of witnesses, experts at that point, and that sometimes the person may not be known or may be changed from time to time. For example, a technology person who's flying someone in, an FBI agent, as we had in a case which was just concluded in the assizes.
I saw that, yes, yes.
Right?
Query
And then
case.
also to, under the rules of disclosure, that you would always know the identity of the person who would be there. Of course, then that would run to the root of how you treat with evidence, what your objections are, etc. So the recommendation was to leave it as it is, it having worked well in other jurisdictions.
All right. No?
Honourable Senators, the question is that clause 5 now stand part of the bill. Those in favour say aye. Aye. Those against say no. Clause 5 now stands part of the bill.
Clauses 6 and 7.
The question is that clauses 6 and 7 stand part of the bill. Yes.
6? AG, at clause 6, I raised this in my presentation. This goes to clause 6A, new subsection, well, new one here, where it says that where a complaint in writing is made to a master that an indictable offense has been committed by an accused, the master may, if he is satisfied that there are reasonable grounds that an indictable offense has been committed. I know we had used reasonable grounds for suspecting throughout the legislation. I don't know if this if it was
So it's
deliberately omitted.
Yes, it's tied to Section 5 of the Act. We're amending Section 6, where reasonable grounds for suspecting are included. I must tell you that the acting CPC next to me, we had a ring-down fight over the need for those words in the first place. She's a very strident person who has worked with multiple AGs.
So she won.
And she won.
Okay. All right. So it was deliberately omitted.
Yes, yes.
Okay.
She won again.
Honourable Senators, the question is that clauses 6 and 7 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 6 and 7 now stand part of the bill.
Clauses 8 to 10.
Honourable Senators, the question is that clauses 8 to 10 stand part of the bill. Honorable Senators, the question is that clauses 8 to 10 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 8 to 10 now stand part of the bill.
Clauses 11 to 15.
The question is that clauses 11 to 15 stand part of the bill. The question is that clauses 11 to 15 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 11 to 15 now stand part of the bill.
Clauses 16 to 20.
The question is that clauses 16 to 20 stand part of the bill. The question is that clauses 16 to 20 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clauses 16 to 20 now stand part of the bill.
Clauses 21 to 24.
The question is that clauses 21 to 24 stand a part of the bill. Senator Hussain.
Thank you very much, Madam Chair. Attorney General, just some clarification with clause 24. I know that you're reverting to the common law admissibility of the evidence. It will both treat with weight and admissibility.
Yes.
What I wanted to find out, I raised it in the contribution, whether or not we would, the records that will be admissible in court, whether or not it will be considered as hearsay. I know that that is why 14B was inserted in the Evidence Act to create that statutory exception. Can you just give me some guidance?
Yes.
With respect to that, please.
There are two methods of admissibility. One of them will be pursuant to the hearsay rule. So it'll be specifically incorporating that. And the law, as it has developed in the period 2000 to 2019 in the UK, Singapore, the rest of the Commonwealth, treats with the bifurcated route that you can actually have the admissibility. So we're leaving it up to the court, really, because if we stick with 14B as it is, it's too technologically specific, and it denies the right of another witness, or in fact the defendant, to cause the admissibility of the evidence.
So practically speaking, at the end of the day, the prosecution, will just require that the record keeper attend court and produce the records?
Yes, yes. The usual methodology of admissibility will apply. Okay. So there'll be a presumption of regularity. It would then be put to the test. You'd have the opportunity to say that you don't accept that and go through the strict formal procedure and have the hearsay admissibility as well.
Okay. Thank you.
Honourable Senators, the question is that clauses 21 to 24 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 21 to 24 now stand part of the bill. I have to say that. Honourable Senators, the question is that the bill be now reported to the Senate. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The bill will now be reported to the Senate. Attorney General.
Madam President, I wish to report that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, was considered in Committee of the Whole and approved without amendments. I now beg to move that the Senate agree with the committee's report.
Honourable Senators, the question is, does this Senate agree with the committee's report on a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011? Those in favour say aye. Aye. Those against say no. I think the ayes have it. Attorney General.
Madam President, I beg to move that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a third time and passed.
Honourable Senators, the question is that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a third time and passed. Those in favour say aye. Aye. Those against say no. No. I think the ayes have it.
A bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011.
Acting Leader of Government Business.
Madam President, I beg to move that this Senate do now adjourn to a date to be fixed. Thank you.
Before? Honourable Senators, before I put the question on the adjournment, leave has been granted for one matter to be raised by Senator Mark.
Yes, I was about to tell you I'm giving the House a Christmas gift.
I take it, Honourable Senators, I take it that I can thank Senator Mark on your behalf. But I now invite members to bring greetings on the occasion of the celebration of Christmas. The Vice President.
Thank you, Madam President, and I too wish to join in terms of congratulating Senator Mark and giving us that beautiful Christmas gift. And that gift in relation to the fact that this is the last day that we will be contributing or sitting in this chamber as a parliament. But Madam President, it is with great pleasure that I bring greetings on the occasion of Christmas and the New Year on behalf of members of the government bench and from the office of the Vice President of the Senate. I take this opportunity to offer heartfelt goodwill, peace, love, and prosperity to each and every one of you. I would also like to remind everyone that in a season of giving inundated with physical gifts, that we remember to give the gift of time to our loved ones, the gift of our hearts to our friends and neighbors, and the gift of the best version of ourselves to our country. Indeed, as we do remember the reason for the season, let us not forget what the birth of our Lord and Savior Jesus Christ represents. And to sum it up in one word, it represents love. Madam President, colleagues, it is also not lost on me the importance of today. This being the final day, the seat of Parliament will be at this location. If these walls could talk, oh, what a story they would tell. This place will always be a part of our nation's history. Therefore, it is only fitting that the final word spoken in this chamber at this location is one of peace, love, and goodwill to all men. Madam President, to the Christian community, to the members of this Senate, to the citizens of Trinidad and Tobago, I wish you a very Merry Christmas and a very prosperous and Happy New Year.
Senator Haynes.
I thank you, Madam President, for the opportunity to bring Christmas and New Year greetings from the opposition bench in the Senate. Christmas time is a time for joy and celebration. Madam President, there's a saying that there's no Christmas like a Trini Christmas, and I believe that with all my heart. It is a time when families gather to spend time together, share gifts, good food, laugh, and create fond memories. But Madam President, please allow me a moment to pause our merriment to spare a thought for our brothers and sisters in Barrackpore, Debe, Woodland, San Francisco, Mayara, and Rio Claro, who are affected, and all the other affected communities in Trinidad. They have endured devastating floods for the 3rd consecutive year, and most will spend their holidays salvaging their humble lifestyles. My heart goes out to them, Madam President, as I saw photos and experienced Christmas trees and decorations under floodwaters. I must pay tribute to the volunteers and generous donors who supported our councillors, MPs, and other officials who were coordinating relief efforts. Our citizens demonstrated great compassion and reverence, which is the central theme of Christmas. And as we stand here, Madam President, and we think there will be little mirth in these homes during this period, as many of us will enjoy our sorrel and pastels and our Christmas fare, I urge everyone to spare a thought and a prayer for those families who are trying to cope with the upheaval of their lives. I urge everyone to continue in the spirit of giving and selflessness that we've seen in the past few days, as we all came together to help our fellow citizens who were affected by the severe flooding. And I give them the message of Christmas: do not lose hope, this too shall pass. This Christmas, it is a time of reflection to strengthen the bonds of love that unite us all. During this holy season, we can draw inspiration from the account of the birth of Jesus Christ. It shows us the importance of keeping the faith in God when all seems lost, as Mary and Joseph did. It speaks to the need for greater compassion, as an innkeeper gave them a safe space, and most importantly, Christmas gives us hope for a better tomorrow. Isaiah chapter 9, verse 6 says, "For unto us a child is born, for unto us a son is given, and the government shall be upon his shoulders, and his name shall be Wonderful Counselor, Mighty God, Everlasting Father, Prince of Peace." This Christmas, let us keep alive faith, compassion. Let us ensure that our country rises up to meet the challenges that we may face. Let us move into 2020 with a positive outlook and renewed commitment to building our nation. From the United National Congress and our UNC family, and on the opposition bench in the Senate, from myself and my family, I wish Trinidad and Tobago a Merry Christmas and God's blessings for a happy, peaceful, and prosperous 2020 and beyond.
Senator Richards.
Thank you, Madam President. And it is my honor to bring greetings on behalf of the independent benches in this season of goodwill. And I thank Senator Mark also for his generosity of spirit. It was 3 minutes to 6 o'clock, and I didn't think we'd be leaving here this early. So, what is the reason for Christmas? Well, quite simply, the reason for Christmas is the birth of our Lord and Savior, Jesus Christ. And Jesus Christ was born for many reasons and displayed many qualities. He displayed leadership because he was a leader of the Christian community. He created Christianity. He was a teacher, and he led by example in everything he said, he thought, said, and did. He showed self-sacrifice, teaching the righteous way, and eventually sacrificing his own life for our ransom, for our sins and our salvation. And he exemplified the qualities of love and purity. As we seek to celebrate Christmas, there are many parallels and lessons, no matter what religious persuasion you may be, in Christmas and in the tenets and taught by Jesus Christ, especially in tough and difficult times, as it was back in Bethlehem at that time in Jerusalem. We are all leaders in our various communities, and we must also understand that and revere that and lead by example. We are all teachers in our thoughts, words, and deeds, and we must also understand that people are watching us. We all must understand our sense of purpose and why we are here, and in the various other walks of our lives. And we must also understand one of Jesus' greatest teachings, which is of self-sacrifice for the greater good of humanity, in this case, our work here for Trinidad and Tobago. These lessons are priceless as we seek to celebrate Christmas, and we seek to also share the examples and live the examples given by Jesus Christ by his life, his teachings, and his eventual sacrifice. So as we prepare to celebrate his birth, let's also connect it with his sacrifice to pay for our ransom and sacrifice for humanity that they may have everlasting life. We have also to, in this time, remember that it is not a time of celebration for everyone in society. While we may be celebrating with our families, and we're grateful for that, there are many others in society who don't, for many different reasons, have something to celebrate. Christmas time may be a time for joy for many, but it's also a time when many think of taking their own lives because they don't get a sense of hope. So if you can think of someone who may be in that position, reach out to someone. If you can give anything, including, as our colleague said, the gift of time and caring, do that and reach out to someone else or a family who may be in need, who may not be celebrating with the rest of us. And I think we'll go a long way into making this country a much better place. So on behalf of the independent benches, because there are 9 independent benches, I would like to take the opportunity to wish you and yours, to you, Madam President, and your family, to our colleagues on the government side and the opposition side, and I also want to single out the Parliament staff who are going to be working through this Christmas season, who have in this place and the other place provided human patriotic service to this country, and they are the unsung heroes in the work that we do. So I want to congratulate them all and thank them, because they'll be working through this Christmas season so that we have a place to continue the work of the people in the other place on the Red House. So on behalf of the independent benches, I want to wish you all a Merry Christmas, a safe Christmas, a sensitive Christmas, a thoughtful Christmas, and a bright, healthy, safe, and prosperous 2020. Thank you.
Honourable Senators, please permit me to join in offering greetings as we celebrate Christmas and as we greet the New Year 2020. But before I do that, may I just give you a short update on the activities of relocating the Parliament. I am pleased to advise that the Parliament has been informed that the restoration of the Red House and the refurbishment of the adjacent Cabildo Parliament complex will be completed by December the 31st, 2019. This means that over the next 6 weeks, the process of relocating the Parliament of Trinidad and Tobago, its auxiliary facilities and staff from Tower D to the Red House and adjacent Cabildo Parliament complex will take place. As you should appreciate, this demanding task will require all of Parliament's resources, particularly its staff, to ensure a smooth transition back to the Red House. Members are therefore asked to note that the relocation will result in a temporary disruption of the auxiliary services which are usually at our disposal. Please bear in mind that sittings of both houses and committee meetings will stand adjourned, and administrative services may become temporarily unavailable during the 6-week transition period. It is anticipated that the move and a resumption of all our processes and services should be completed by Monday, January the 20th, 2020. I wish to assure all members that the clerks of both houses will make every effort to apprise you of all available information and details during this transient disruption as the Parliament of Trinidad and Tobago returns to its home at the restored Red House. Honourable Senators, as we have heard from all those who have brought greetings prior to me, the messages of Christmas, namely of hope, of renewal, of generosity and peace and goodwill to all, are embraced not only by Christians, but by all of mankind. They are messages that are especially important in Trinidad and Tobago at this stage of our nation's development. They serve as a clarion call for reflection, for self-correction, and more importantly, for action. These are qualities that our country needs not just at Christmas, but all the time. My wish for everyone in this chamber and beyond is for a brighter tomorrow built on the foundation of the messages of Christmas. May that foundation help all of us in this chamber to work together now and in the new year to improve the lives of all of those whom we collectively serve. On behalf of the Parliament of Trinidad and Tobago and on my own behalf, I wish all members here, I wish your families all the very best for Christmas and for the new year. May I also add to what Senator Richards has said. We need to thank the members of staff of Parliament, both the Clerk of the House and the Clerk of the Senate, for the tremendous service that they offer to us. They have seen about our every need, and they have made sure that we are comfortable and want for nothing as we serve in this chamber. And they are, during this transition period, putting all of their efforts and putting aside their time with their families to make sure that this transition happens. So I want to offer in advance, I want to say to them, thank you for all that they have given us in 2019, all that they will give us in 2020, but more so all that they are giving us during this Christmas season. So I thank them. Honorable Senators, the question therefore is that this Senate do now adjourn to a date to be fixed. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to a date to be fixed.